Wait, please, Your Lordship. My Lord, I have taken instructions. Lord, out of all the questions, my Lord, two questions, Lord, I was to take instructions. A, whether a writ petition would lie at the behest of the state government under Article 32, read with 226. And second, the scope and ambit of Article 361 in the context in which your lordships are, my Lord, examining the issue. My Lord, the Honorable President would like your lordship's opinion on that, my lords. And there are reasons. Your lordships are aware the opinion will be requested when a question has arisen or when a question is likely to arise. My Lord, these are the two contingencies under which, my Lord, inter alia, the Honorable President can, my Lord, seek your lordship's opinion on that. Please have a look at, my Lord, how this question has arisen but will definitely arise. And I am showing the view in Tamil Nadu, my Lord. I am conscious it's not an intra-court appeal, but it's a view decided and legal view your lordships can, my Lord, as held in the 2G case, interfere with. My Lord, please have a look at, my Lord, first, page 12509, volume 5.31. We, my Lord, examined this. We went to this.
The question is whether a petition under Article
32 or 226 would be maintainable in the context of the power or function, my Lord. Power is a little harsher word. Function exercised respectively by the Honorable President of India and the Honorable Governor under Article 111, Article 200 and Article 201 of the Constitution of India.
An exercise by President or Governor.
Governor respectively under Article 111 and 201 and by the Governor under Article 200. But this, my Lord, was not, my Lord, none of us assisted your lordships on this. And I'm the only one, my Lord, who is going to make submissions on this. Others, my Lord, would not trouble your lordships, my Lord.
What is the page that you have referred to just now?
12509.
That's it.
Para 367. Lord, PDF would be 336. In that volume, my Lord.
Paragraph 367.
367.
Yes.
The Honorable Bench is pleased to summarize the conclusions. Kindly come to A. Because this will have to be examined, my Lord. Otherwise, my Lord, questions will keep on arising. Which question is already, my Lord, put for your lordship's kind opinion. Your lordships, may I read, my Lord? A. Where the governor reserves a bill for the consideration of the president in his own discretion and contrary to the aid and advice tendered by him by the State Council of Ministers, it shall be open to the state government to assail such an action before the appropriate High Court or this court. Such a challenge can broadly be made on the following grounds. So first, it can be a 32, it can be a 226 petition, and these are the grounds. Please read. Where the reservation is on the ground that the bill is of a description falling under the second proviso to Article 200, it may be assailed on the ground that the bill or any provision thereof does not so derogate from the powers of the High Court so as to endanger the position which the court is designed by the Constitution to fill. The governor, while reserving a bill on this count, shall be expected to provide clear reasons and also point to the specific provisions of the bill which, in his opinion, attract the second proviso. This is, my Lord, difficult part. This question being purely of a legal nature would be completely justiciable. My Lord, meaning thereby the legal view is whichever is legal question is justiciable question. I'll come to that, my lords. And the competent court would be after a proper adjudication, fully authorized to approve or disapprove such reservation by the governor. If such a challenge finds favor with the competent court, then, subject to other considerations, it would be a fit case for the issuance of a writ in the nature of mandamus to the governor for appropriate action. I'll come to that, my lord, whether a writ would lie against the governor, my lord, under the scheme of the constitution. When your lordship examines governor's function or exercise of power under 356, my lord, presidential rule, failure of law and order, Article 356 provides for a contingency, that if there is a failure of law and order,
Conditions on which the power can be exercised.
power can be exercised, and your lordships would not be issuing a mandamus to the governor. Your lordships would be setting aside the order whereby the president's rule was imposed. Lord, further, then Roman 2, where the reservation is on account of the bill attracting any provision of the constitution whereas the assent of the president is a condition precedent for the proper enactment and enforceability of such a bill as a law, such as under Article 364A2, or for the purpose of securing any immunity or overcoming any repugnancy that may exist qua a central legislation, then the governor is expected to make a specific and clear reference to the president, properly indicating the reasons for such reservation and inviting his attention, that is president's attention, as described in Kesare-Hind. Such a reservation can be assailed by the state government if the reference made by the governor either fails to indicate the reasons for such reservation as discussed above, or, please mark, the reasons indicated are wholly irrelevant, mala fide, arbitrary, unnecessary, or motivated by extraneous considerations. So not only petition would lie on these grounds, and when petition is filed, these are the considerations, even unnecessary, that it was not necessary. We feel it was not necessary, so we substitute our decision to that of the governor and direct the governor by a writ of mandamus. Further, then such a reservation would be liable to be set aside. This question, being purely a legal nature, would be completely justiciable, and the competent court would be, after a proper adjudication, fully authorized to approve or disapprove of such a reservation by the governor. Meaning, thereby, my lord, again, law is, if something is legal, it is justiciable. If such a challenge finds favor with the competent court, then, subject to any other considerations, it would be a fit case for issuance of a writ in the nature of mandamus to the governor for appropriate action. So, my lord, it is kind of a advance ruling, my lord. Now, my lord, kindly see 12582 or 578, 12578. One two five seven eight. My lord, I'm sorry, 12513, my lord, my lord. If kindly, my lord, see 12513. My lord, there is a time limit prescribed, and my lord, kindly see 12513, my lord, Roman 5. Does my lord Justice Narasimha gets, my lords get, where the governor exhibits inaction in making a decision when a bill is presented to him for assent under Article 200, and such inaction exceeds the time limit as has been prescribed by us in para 250 of this judgment, then it shall be open to the state government to seek a writ of mandamus from a competent court against the governor, directing expeditious decision on the concerned bill, as is the mandate of the Constitution. However, it is clarified that governor may successfully resist such a challenge on providing sufficient explanation for the delay caused. Lord, governor can't even be called upon, my lord. My lord, here, my lord, in substance, my lord, the court doesn't use the way in which, my lord, I am describing it, that Mr. President, you decide within 3 months. You better give your reasons. My lord, I have shown that. And the state government, if she doesn't do it, come to us. That, my lord, with profound respect, is not the constitutional scheme. A, 32 does not lie. 2, mandamus cannot be issued. And 3, it is not justiciable. Every question which is legal is not justiciable. Now, my lord, come to page 12578. And, my lord, this will have a far-reaching ramification. Therefore, my lord, after considered debate, my lord, at our end, my lord, the Honorable President decided that it's better that we know what is the legal position, and therefore we must request for the opinion of your lordships. My lord, 12578, para A, Roman 1. These are also, my lord, the penultimate para. These are the final directions, where the reservation is on the ground that the bill is of a description falling under, that is, my lord, the same thing. And, my lord, I'll not, same conclusions, my lord, are repeated. My lord, in the final chapter, my lord. I'll just, my lord, place my short note. And my lord, I can assure your lordships, I'll not read everything. The copies are given, my lord. I have prepared this. Lord, it would be volume 1.8. Lord, volume 1 should have been the Learned Attorney General's volume, but since mine was filed first in point of time, Lord, the numbering is accordingly given. Lord, I'll just broadly indicate and read only those paras which would assist your lordships, my lord, directly. Everything, my lord, is there, my lord, for your lordships to consider, and everything will assist your lordships. But, my lord, considering that I am, my lord, raising this issue with your lordship's permission at the end, and nobody else is going to, my lord, raise this issue, my lord. This is our collective work, my lord, which I am presenting before your lordships. My lord, first, whether a writ petition under Article 32 would lie at the behest of the state government, my lords. My lord, there are two objections, and based upon which, my lord, we request your lordship's opinion whether your lordships would entrust or empower the state government to file a writ petition, my lord, because you have to seek source of your right. This is the court given right, my lord, that you all right, you come to us. My lord, there are two objections. A, 32 lies when there is a violation of fundamental rights, and the state government as a constitutionally formed body per se cannot have fundamental rights. It may represent fundamental rights of others, but otherwise the scheme of the constitution is state government is repository of functions which is to protect the fundamental rights of everyone. My lord, a similar question arose even by an individual. My lord, what happened was the house was prorogued by the speaker, which was illegal, and one member of parliament approach your lordships under Article 32 of the Constitution, and the question squarely arose whether a 32 petition would lie. My lord, please come to, my lord, page 3 of my note. My lord, the bottom is the pagination. My lord, your lordships may bear one factor in mind, my lord. Kindly, my lord, this was, my lord, highlighted, but, my lord, I feel, my lord, it could not be highlighted as much as we wanted to highlight it. My lord, there are chapters under the Constitution. Your lordships would find chapter 200, article 200 in the chapter which starts with legislative procedure. So please come to 196, article 196. 196, just above that, heading, my lords. 196, provisions as to introduction and passing of the bills. I'm not reading it. The legislative process starts with introduction of the bill. Obviously, it's a part of the legislative process. Then it goes up to Article 200. The legislative process culminates, ends when the governor discharges one of his choices out of the four, or the Honorable President, on being reserved, exercise the proceedings, exercise the choices under Article 201. So Article 196 to 201 is a part of the legislative process. It has as much sanctity as proceedings in the House before in the House. And thereafter, the new chapter starts, procedure in financial matters. When a bill is involving issues with regard to financial bill, etc., etc. So, my lord, my first respectful submission for your lordship's assistance is that it is a part of a legislative process, and the question would be, can any part of it be subjected to writ jurisdiction on the ground that fundamental rights are violated? Please have a look at page 721. The bottom pagination internal is 3. Ramdas Athavale versus Union of India. It was held that the validity of the speaker's decision adjourning the House sine die and later directing to resume.
Where are you reading?
Lord, I'm sorry, page 721. My note,
Yes.
top pagination is 721.
Ramdas Athavale.
Ramdas Athavale. What is 5? Yes, madam. It was held that the validity of the speaker's decision adjourning the House, sine die and later directing to resume its sittings cannot be inquired into on the ground of irregularity of procedure. The relevant paragraphs reads as under. It is equally well settled that Article 32 of the Constitution guarantees the right to a constitutional remedy and relates only to the enforcement of the right conferred by Part 3 of the Constitution, and unless a question of enforcement of a fundamental right arises, Article 32 does not apply. It is well settled that no petition under Article 32 is maintainable unless it is shown that the petitioner has some fundamental right. In so-and-so versus so-and-so, this court has made a pertinent observation that when a person complains and claims that there is a violation of law, it does not automatically involve breach of fundamental right. My lord, similar judgment is, my lord, I'm not, my lord, reading it, but where they say even private party cannot come directly to the court under 32, that there is a violation of law, because you will have to show
Unless there is a
violation of fundamental rights, my lord. My lord, kindly see, Lord, one provision of a constitution can bar jurisdiction of the High Court or the Supreme Court in another provision of the same constitution. Lord, that question arose when state of Karnataka came here in a 32 petition with regard to water dispute. And this honorable court was pleased to say that we have a separate article, Article 262, for dealing with intrastate water disputes. And therefore, you cannot come under 32. My lord, please come to 722. My lord, I am also saying 131 would also not apply, but I would, my lord, come at at the end. My lord, please see, there are, my lord, this is Atmaling Reddy versus Union of India, where he was a man, my lord, according to, my lord, it appears, my lord, sponsored by, not sponsored, but put up by the state. Article 131 of the Constitution, which enables the central government or a state government to institute a suit in this court on its original side in certain cases, also cannot be invoked in interstate water disputes in view of Section 11 of the Act. In other words, the provisions of Article 131 of the Constitution have to be construed harmoniously subject to provisions of Article 262 of the Constitution. A petition under Article 32, hence, cannot be entertained by this court. Well, this is only for the limited purpose that one constitutional provision can also bar jurisdiction under Article 32. Now, my lords, may kindly come to para 7. Lord, the possible argument that we are coming here in a representative capacity because we represent the people. It's a quite possible argument and a permissible argument. They do represent the wish of the people. But question is, would that entitle them to invoke your lordship's jurisdiction under Article 32 of the Constitution? Because as I have already said, the solution lies elsewhere. 32 would not be maintainable. I am only on maintainability. Please have a look at para 7. It is submitted that Article 32 is a remedial provision meant for enforcement of fundamental rights under Part 3. A state is itself the state within the meaning of Article 12 and is the bearer of constitutional duties not the holder of Part 3 rights. Therefore, a state cannot maintain a petition under 32. For the same reason, a state cannot use 32 to litigate fundamental rights in a representative capacity. Article 32 requires the petitioner's own Part 3 right to be in issue. So that's how article is worded, that petitioner's fundamental right. My lord, your lordships have exempted this only when the concerned petitioner is unable to approach. My lord, workers,
On account of social and economic disability.
economic, my lord, and not to the government. Government cannot come. It's the duty of the government to protect them. Some non-governmental organization comes, some individual in a representative capacity comes. Now, please, my lord, come to Lord, directly page 725. My lord, I have cited judgments, my lord. I'm not reading them. Relevant part is highlighted. Sorry. Yes, my lord, 725. My lord, I have said that, my lord, kindly, I'll read para 13, my lords. In view of the above, a state which does not have any fundamental rights cannot file a petition under Article 32 for any purpose whatsoever. Permitting states to file Article 32 would amount to turning the scheme of Part 3 on its head. The center-state relationship is governed by Part 9, 10, 11, 12, and 13 of the Constitution. The disputes between the governments are dealt with in Article 131 of the Constitution. A state government or even the central government cannot invoke Article 32. But this would be very, very relevant. Kindly imagine a converse situation. Look, there is a law and order situation in one particular state, and such instances have arisen. My lord, I'm not giving a hypothetical example, but without naming the state, where there is eruption of my lord, violence. The local police is unable to contain violence, either because of inefficiency or because of inadequacy of the force or for various, my lord, other reasons. And if the central government says, and which it can say, my lord, under the Constitution, that you deploy paramilitary forces for protecting the fundamental rights of the citizens, and the state refuses to do that. Lord, I am putting a question to myself, can the central government file a petition under Article 32 seeking a direction of your lordships, directing the state government to deploy paramilitary forces, my lord? My answer would be, my lord, in the negative. It cannot be done. Yes.
But nobody is to.
No, he is rejecting my submission, my lord. So I'm saying, please don't do that. You will oppose every submission, but not now. That's simultaneous. Lord, now, Lord,
Yes, proceed.
he can never, my lord, disturb me without my consent. I refuse to be disturbed. Lord, page
Then why are you getting-
725. Lord, bottom, Lord, this is.
Why are you getting disturbed if you can't be disturbed?
No, I'm just telling him that please don't do this. 725, my lord.
Yes.
Lord, this is American law, my lord, which I generally do not cite, but please have a look at, my lord, this. And therefore, I have not quoted in extenso.
Tara?
My lord, at the footnote of page 725.
Teacher.
In American constitution law, it is settled law that the states cannot assert the rights of their citizens as parens patria and approach the Honorable Supreme Court of the United States under its original jurisdiction when the defendant is the federal government. My lord, states there, my lord, are quite independent. It's not a part of a federal whole. They have their constitution, they have their separate flags, they have their separate Supreme Court. They say that these are federal issues between the state and the center, and we would not kind of work as a headmaster between two fighting students. My lord, in main submissions, my lord, I ignored that, my lord, but we have cited American cases also, that where the federalism is of a different nature. There were questions of deployment of forces, my lord, in American courts. But they say that you cannot come to the Supreme Court for this. These are federal issues decided politically. We would steer away from such issues being examined at the judicial level. Now, my lord, para 17, I have said, my lord, and I orally paraphrase, I will not read it. My lord, I am coming now to Article 226. My lord, what would Article 226 entitle or empower the High Court to do? And let us examine each. Writ of habeas corpus, no question from in the facts of the case. Writ of certiorari it applies to, my lord, tribunals, quasi judicial bodies, etc. Writ of prohibition, when some statutory authority is discharging some function or constitutional authority is discharging some statutory function, non-constitutional function, in a manner which it should not, then he will be prohibited. The question cannot arise in the context of Article 111, 200 and 201. Quo warranto is not a situation, then only remedy left is mandamus. Now, kindly examine a situation, my lord, and take each of the options available to the governor. If he grants assent, my lord, can someone who is aggrieved by grant of assent, state would not be aggrieved, but someone aggrieved by grant of assent, can he challenge before your lordships, and can High Court issue a mandamus that assent is bad? Because then you are examining a law.
No, that is a totally different situation.
Then you will
Because
say the law.
Once a law, after the assent is granted, the law stands enacted.
So the law will be challenged, not the assent.
So the validity of the law
Yes,
can be
exactly.
challenged
I'm grateful.
on the grounds parameter available to it.
Correct.
But that's a different situation. But the question is when the honorable governor sits for a bill passed by legislature, and maybe on the second occasion also, can he just sit on for time immemorable?
I have already argued that, my lords, because justification will not confer jurisdiction. If it is not justiciable, it is not justiciable. My lord, and therefore, please, my lord, at the cost of repetition, I am urging few facts which are, my lord, only few facts are before your lordships. They, my lord, chose not to, my lord, undertake any political process. Otherwise, my lord, every state.
The Constitution debate show that earlier, before as soon as possible, the word used was within 6 weeks.
Correct, in the proviso.
And thereafter, one of the honorable members suggested, you don't look at that side. You are addressing us, not them.
No, he is behaving.
According to him, you are Hari Vishnu Kamath.
And he is so much agitated that he replies to every contention sitting there in my hearing.
No idea as to how this court functions.
Anyway,
I know, my lord. I know, my lord, because I would not prepare.
Anyway, we are not supposed to resolve that dispute here.
No, my lord, that's.
We are sitting in a presidential reference.
Lord, my
You-
learned friend is right.
At 1 o'clock, both of you go for a cup of coffee and resolve
No,
it.
my lord, we can even have a meal. There is no difficulty, but I agree. I do not have any idea as to how the courts function because I do not make reels and make it viral that how beautifully and brilliantly
let's stop at
I
that.
argued this. But leave it at that, my lord. It would not be proper, my lord, to be personal.
As you see
Now,
the-
my lord,
if
your
you
lordship.
see the debate, the earlier suggestion was that it should be within a period of 6 weeks. Then it was found that the time bound rule may not be appropriate. And therefore, it was made as soon as possible. And one of the members also made a discussion, said that the very purpose of using the word is as soon as possible means immediately,
Earliest,
without any delay,
at the earliest.
at the earliest. And therefore, the suggestion was as soon as possible, but not later than 6 weeks.
Understood. my lord. I bow
That
down.
also was not accepted.
I bow down, and
So
therefore,
therefore, the constituent members of the Constituent Assembly had what had they in their mind was that the Honorable Governor would
is
look at the issue
expected to
with
decide
the
at the earliest.
expected exigency.
Correct.
And if that was the intention of the constitution makers, can we ignore that?
My lord, again, my lord, with respect, my lord, I'll put it a little, my lord.
You won't disagree that while interpreting the provisions of the constitution, we can go into the constitutional debates.
Certainly, I am relying upon, they are relying upon, everyone is relying upon. There cannot be any argument. But, my lord, the example which your lordships are giving, and very rightly giving, would mean that the governor is expected to react immediately. But we do
Not
not
immediately, but within a reasonable period.
reasonable period, my lord. I'm not on the time limit. But sometimes, my lord, what is that time limit, my lord? That depend upon facts
It
of
depends
each
on facts.
case.
It will
And your
depend upon
lordship-
circumstances.
Yes.
So whether the court would not be justified to find out whether the circumstances were correct or not, or the governor, I won't use the words which are used by the division bench, but was not justifiably or was not justified in setting out the bill for 6 months or 1 year.
My lord, again, I'm going back to my earlier argument, and I'm not going to repeat it, my lords, that one constitutional co-organ not discharging its duties or not discharging in time will not confer jurisdiction on another constitutional organ.
Yes, we recollect your argument that if this court doesn't decide a matter for 10 years, would the president be justified in issuing an order?
It was an example given. It was not, my lord, an argument that justification cannot confer jurisdiction. Lord, it is expected, and if that happens, the solution lies outside the court rather than
That
advising
we
the
can do.
state to file petitions. That's, my lord, the respectful submission. Now, my lord, what would your lordships do? My lord, suppose it is withheld. If it is an assent, your lordships would examine the bill. But there is a possibility that assent is granted. Forget the delay part. I'm not on delay part. Assent is granted immediately. Someone is.
Then it becomes a law.
Give me a minute more, my lord. It becomes a law, and law can be challenged on various grounds: repugnancy, fundamental
On
rights.
limited grounds.
What,
On the limited grounds that are available.
whatever, my lord, it's a law is settled, and I'm not going into it. But, my lord, there can be instances where, kindly, my lord, consider this argument a little minutely. Lord, suppose the outgoing ministry at the fag end of their tenure passes a law hurriedly. I'm giving an example. The governor grants assents. The new ministry comes, and new ministry challenges the assent. Lord, I am giving a hypothetical example. What mandamus the court can issue? Would the court be able to say,
The new government comes, it's always available for the legislature to change the law.
I'll come to the second point. I'll come to the second option. My lord, suppose the bill is withheld, and withheld means, my lord, as we have understood, it falls through. That withholding is challenged. And if your lordship finds, and if your lordship says that your lordship would have the jurisdiction, that it should not have been withheld, your lordships will have to necessarily say that we set aside the order of withholding and issuing a mandamus for the governor either to assent the bill or refer it to the president. Lord, the question for your lordship's opinion is, can such a mandamus be issued? Suppose the division bench says that even if it is referred to the president, a party can come here, the state can come here, not party. State can come here, that it is wrongly referred for the consideration of the president under the first proviso. My lord, would your lordships, my lord, I am posing a question to myself in a 226 or 32, say that no, it is wrongly referred, and therefore we set aside that order of referring it to the president and we direct by way of a mandamus to grant assent to the bill. Your lordships have said time immemorial, my lord, time after time, judgment after judgment, your lordships will not issue a mandamus to implement a particular law or make a particular law. Mandamus directing issuance or directing grant of assent would necessarily, inevitably mean that your lordships are directing making of the law. My lord, in A.K. Roy, your lordships have said that even if the constitutional amendment is passed by the parliament, not brought into force, a petition was filed, the court said, this is not our domain. We cannot ask them to implement this particular law. My lord, this position would be no different. Your lordships, if there is an availability of mandamus, will have to say either under Article 32 or 226 that I set aside the order of withhold, meaning thereby you decide it, you grant assent, or you refer it to the president, and that reference also is a subject matter of challenge before this honorable court, and the states would be advised to file a petition rather than taking any other constitutional option available. So, my lord, by very nature of the function and the position of the governor, the nature of the power conferred under Article 200, my lord, a writ of mandamus cannot be filed, and therefore 226 will not lie, my lords. That is, my lord, my respectful submission. My lord, in this context, my lord, I have cited laws that your lordships were, my lord, approach that direct the government to make rules, direct the government to make this law. Your lordships refrain from doing that. That's not the domain of the court.
No, we even refrain from entering into the policy matters.
Exactly, my lord. Even administrative, executive policy decisions. But here your lordships will have to say that governor who cannot be joined as a party, who cannot be called upon to explain, the my lord, division bench legal view is that governor will have to come and explain that what was the delay, why he referred it to the president, what is the reason for withholding. My lord, Article 361, my lord, becomes nugatory, my lord, if your lordships accepts the state's power to file a petition, my lords. My lord, now kindly see, lord, in S.R. Bomai, my lord, I'll read only 2 paragraphs and I'm not doing anything further. But please bear one distinction in mind.
You are saying all such directions can be given under 131?
No, my lord, I'll answer that immediately.
So therefore, the issue of forum is irrelevant.
No, my lord, I'll just answer that question.
Is there a forum at all for that?
Well, that's my case. It's not justiciable.
No forum. The issue of whether 226, 31, 32 was all irrelevant.
Correct, my lords.
What's the
And
matter
I'll answer your lordship's question on 131. Why I say this? I'm sorry, my lord, the Chief Justice is reading something.
Yes,
But 131, why it would not lie? So 131 is a provision where your lordships examine and adjudicate a dispute between Union of India and the state government. Here, one party is the state government. But governor is not Union of India. He is not a representative of Union of India. He represents the Honorable President of India. And therefore, any dispute between the state government,
how do you say that he doesn't represent the government of India?
no, he represents the President of
The government of India, the executive authority vests in the president.
No, constitutionally speaking, he represents the state. He is head of the state executive, representing
As a representative of the central government.
President of India, my lord. That's
No, the constitutional debate says that he is a vital link between the central government and the state government.
no, kindly, my lord, have a look at, my lord, the provision. My lord, 155. Kindly,
So if you go through the constitutional debate
yes,
as to whether there should be a governor or should not be governor. So the framers of the constitution found that the governor has to be there so that a vital link is provided between the state government and the central government.
kindly look at it from a different angle. I'll show 155, but a slightly different angle. is the president under Article 200 bound by the aid and advice of the central government? The answer is no. There are only two contingencies.
Central government, the president would be bound by the aid and if you.
I'm on governor. I'm on governor. Right now, I'm on governor. The governor can either decide based upon the aid and advice of Council of Ministers of the state or in his own discretion. He may represent the central government in a broad sense as understood in the Constituent Assembly debate. But he is appointed by the President of India and he is reporting and answerable to the President of India. And there are several constitutional functionaries who are appointed by the President of India, but they do not represent the central government. Please have a look at Article 155. Lord, I'm putting a question little differently. Suppose the governor's action is under challenge. Can the central government come here and start defending the governor? Cannot. Lord, in most cases, it is the state government which appears and defends the governor. And this is the constitutional reason behind it. Lord, we are not on A situation or B situation. Lord, I'm just assisting on a constitutional scheme. Lord, 155 says, the 154 first, my Lord, the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him. Then, my Lord, 155, the governor of a state shall be appointed by the president by warrant under his hand and seal. Lord, what is envisaged is that there would be a person who will deal with the national policy vis-a-vis the state level policy. But he is not the same thing as Union of India for the purpose of Article 131. Article 131 is central government versus state government dispute. Dispute regarding the boundary, dispute regarding the powers, dispute regarding the allocation of funds, etc., etc. Directly central government, directly state government. Because if we my Lord, extend this logic, then even CAG is, my Lord, appointed by the President of India. Election Commission is appointed by the President.
Mr. Prasad One,
Yes,
his question was slightly answered,
Yes.
saying that the actions of the government, of course, there is an immunity, but if at all he needs to answer, that answer will come through the government. Rameshwar Prasad One, not two.
Yes, my Lord, but the government of the state, because he heads the state. My Lord, I kindly appreciate, my Lord, he can't be joined. If a mandamus were to be issued, he will have to be joined, then we will be violating Article 361. And who will defend him? The state may not, because the state is the petitioner. Central cannot, because I can't come and say that, no, he's my representative. He did it at my behest. No, that's not the constitutional scheme. Lord, kindly see, my Lord, and the question of justiciability is a separate question, my Lord. But now please come to, my Lord, I'll, my Lord, at the end read only few paragraphs from Bomai. But bear, my Lord, but first, my Lord, I'll read few paragraphs from Bomai. My Lord, kindly bear one factor in mind. Bomai was a case where the governor's action under Article 356 of the Constitution was impugned. Article 356 has an inbuilt condition incorporated. When can you invoke? When there is a failure of law and order. And therefore, your lordships had a test to apply whether the governor's decision fall within this constitutionally framed condition under Article 356 or not. It was not, my Lord, a constitutional decision in the sense in which, my Lord, we are respectfully submitting under Article 200. Now, my Lord, kindly have a look at, my Lord, only few paragraphs, my Lord. Lord, volume number 5.14. My Lord, your lordships may first, my Lord, take only paragraphs, my Lord, I'm giving. I'll read 2 or 3 paragraphs.
Volume?
My Lord, volume
14.
5.14.
Page?
My Lord, it starts at Lordship will give me a minute. 5478.
5478.
78. Lord, kindly note the para numbers. I'll read only 2 or 3, but all are, my Lord, relevant. Lord Justice Ahmadi, para 32 and 35.
Yeah.
32 and 32 TO2 35. Then Justice Verma for himself and Justice Yogeshwar Dayal, para 40 to 49. Then Justice Sawant for himself and Justice Kuldeep Singh, para 59, 60, 62, 74, 83, 86, 96, and 153. Then, my Lord, Justice Ramaswamy, para 198, 201.
One minute.
I'm sorry, my Lord.
Yes, Mr. Ramaswamy.
Para 198, 201, 211, 256-258. So Justice BP Jivan Reddy has expanded the scope of this court's jurisdiction, my Lord, and said that it is amenable and there is justiciability, my Lords. That is para 331, 372.
One minute.
I'm sorry, my Lords. Lord, 331, 372 to 376. Lord, they are all extracted in our main note at page 305 to 308. But please read, my Lord, only one paragraph of Justice Ahmadi. It's a majority view. Lord, kindly come to page 5558. Lord, this was again, my Lord, at the cost of repetition, a case of 356, where there was a binary. You can appoint or you cannot appoint precedence rule. Why? For what reason? What should be the ground? Failure of law and order. Here, my Lord, we are dealing with a situation with multiple options and multitude of contingencies under which, my Lord, those options are to be exercised. Lord, 35, Lord, somewhere from classitum G, the expression otherwise, your Lordship gets, my Lord?
Yes.
The expression otherwise is of a very wide import and cannot be restricted to material capable of being tested on principles relevant to admissibility of evidence in court of law. Now, please see, it would be difficult to predicate the nature of material which may be placed before the President or which he may have come across before taking action under Article 356(1). Because not only material provided by the Governor, President can have other material also. Besides, since the President is not expected to record his reasons for his subjective satisfaction, but the article doesn't say you record your reasons. That is read for the first time, my Lord, in Article 200. It would be equally difficult for the court to enter the political thicket to ascertain what weighed with the President for the exercise of power under the said provision. The test laid down by this court in barium chemicals and subsequent decisions for adjudging the validity of administrative action can have no application for testing the satisfaction of the President under Article 356. It must be remembered that the power conferred by Article 356 is of an extraordinary nature to be exercised in grave emergencies, and therefore the exercise of such power cannot be equated to the power exercised in administrative law field and cannot therefore be tested by the same yardstick. Please note this, my lord, and kindly underline, several imponderables would enter consideration and govern the ultimate decision, which would be based not only on events that have preceded the decision, but would also depend on likely consequences to follow, and therefore it would be wholly incorrect to view the exercise of precedent satisfaction on par with satisfaction recorded by executive officers in exercise of administrative control. The opinion which the president would form on the basis of governor's report or otherwise would be based on his political judgment, and it is difficult to evolve judicially manageable norms for scrutinizing such political decisions. It therefore seems to me that by the very nature of things which would govern the decision making under Article 356, it is difficult to hold that the decision of the president is justiciable. My lord, it's not on the question of jurisdiction of this court, it's justiciability. And my lord, para 34, your lordships can mark, there is a marked distinction shown in the judgment only. What is the distinction between judicial review and justiciability? Something can be within your lordship's judicial review power, but can still not be justiciable. Here, my lord, we are dealing with a situation where, my lord, the law as developed says that it's a question of law and therefore it is justiciable. Now, to do so would be entering the political thicket and questioning the political wisdom which the court of law must avoid. The temptation to delve into the precedent's satisfaction may be great, but the courts would be well advised to resist the temptation for want of judicially manageable standards. Therefore, in my view, the court cannot interdict the use of constitutional power conferred on the president under Article 356 unless the same is shown to be mala fide, because it was ultimately an administrative decision, not a legislative decision, where mala fides cannot be attributed. Then, my lord, after E, classitum E, I am also in agreement with Justice Verma when he says that no quitimate action would be permissible in such cases, etc., etc., my lord. Now, my lord, kindly come to para 216, Justice Ramaswamy. My lord, rest, my lord, I am not troubling your lordships, my lord. At 5664. Your lordships, my lord, got it? Para 216. To test the satisfaction reached by the president, there is no satisfactory criteria for judicially discoverable and manageable standards that what grounds prevailed with the president to reach his subjective satisfaction. Please see under Article 201 or 111.
5645.
Lord, 5664. 5664.
216.
Yes. To test the satisfaction reached by the president, there is no satisfactory criteria for judicially discoverable and manageable standards that what grounds prevailed with the president to reach his subjective satisfaction. There may be diverse, varied, and variegated considerations for the president to reach the satisfaction. The question of satisfaction is basically a political one. Practically, it is an impossible question to adjudicate on any judicially manageable standards. Obviously, the founding fathers entrusted that power to the highest executive, the President of India, with the aid and advice of Council of Ministers. The satisfaction of the President being subjective, it is not judicially discoverable by any manageable standards, and the court would not substitute their own satisfaction for that of the President. The President's satisfaction would be the result of his comprehending in his own way the facts and circumstances relevant to the satisfaction that the government of the state cannot be carried on in accordance with the provisions of the Constitution. There may be wide range of situations and sometimes may not be enumerated, nor can there be any satisfactory criteria But on a conspectus of the facts and circumstances, the president may reach the satisfaction that the government of the state cannot be carried on in accordance with the provisions of the Constitution. Therefore, the subjective satisfaction is not justiciable on any judicially manageable standards. Moreover, the executive decision of the president receives the flavor of the legislative approval. No, that is something different because that has to go before the House. We are not concerned with this, my lord. I am relying upon this, my lord, to show that multitude of considerations go into the decision making, whether to grant assent, withhold assent, refer it to the president, or resort to the proviso. And one consideration can be to let the situation cool down. Suppose a parliament passes a law, assembly passes a law that except a particular local language, we will not permit use of any other local language. Maybe it is within list 2. And waiting for 1 year may be considered by the governor in his constitutional wisdom to be a wise thing to do. Lord, then kindly come back to my note, my lord. I am not reading any other. My lord. My lord, I have relied upon page 720.
How much more time is required?
10 minutes.
More than 1 hour.
I'm sorry.
That's in half
My
an hour.
apologies, my lord. Your lordships have been very indulgent, my lord. My apologies to my learned friends also, particularly Mr. Sibal.
Oh, we'll have to compensate that time.
I will.
We will have to compensate. Or you will compensate from your rejoinder, then it's okay.
No. But I will compensate outside the not, my lord. I can't compensate the time, my lord.
Just, if I may just have liberty for a moment.
No. May what?
I have signed it from.
That's all. My lord, I have cited AK Call. I am not reading it. Your lordships may kindly read it. But please, my lord, come to page 730. On the lighter side, Lord, for the first hour, Lord, we did not start arguments. First hour was on the preliminary issues raised by them. So nobody needs to be compensated. Now we are being compensated for that 1 hour which we lost on the lighter side. Well, entirely your lordship's discretion, my lord.
So 4 days was including 1 hour for the preliminary.
Your lordships are right. I am saying on the lighter vein, my lord. Your lordships can, my lord, extend time, curtail time. My lord. That's absolutely my lord's discretion. My lord, page 730, my lord, I have cited one British judgment, my lord, which I generally do not cite, but 2 reasons. A, my lord, our writ power is, my lord, prerogative writs as was available in England. And second, our constitution is essentially and broadly framed on the British parliamentary system. My lord, only one paragraph. And, my lord, this judgment is cited in India from beginning, my lord, not in a recent time, my lord. From the beginning, and it has, my lord, it is cited with approval of this court, my lord. My lord, kindly see 731. But I do not think that the right of challenge can be unqualified. It must, I think, depend upon the subject matter to the prerogative power which is exercised. Many examples were given during the argument of prerogative powers, which, as at present advised, I do not think could properly be made the subject of judicial review. Prerogative powers such as those relating to making of treaties, the defense of realm, the prerogative of mercy, the grant of honors, dissolution of parliament, and the appointment of ministers, as well as others, are not, I think, susceptible to judicial review because their nature and subject matter is such as not to be amenable to the judicial process. Now, my lord, I have given 4 classes.
But in England, the powers of the High Court are much restricted as compared to the powers of our High Court.
Correct, my lord, correct. They cannot even go into the question of validity of a law.
Validity of a law.
I am, my lord, on a limited point. Then there are certain prerogative functions of co-equal constitutional functionaries which would not be subjected to prerogative writs by the judiciary. My lord, that is what, my lord, this judgment says. My lord, your lordships would be guided. My lord, that's my respectful submission. My lord, by these 4 factors which I am not reading or elaborating, the authority, which authority the government is exercising under Article 200, what are the nature of its functions? Second is nature of the function. Third is the stage of the process. But your lordships are, my lord, as my lord held in the judicial view taken by the division bench, there is a permissible approach to Article 32 or 226 at a stage where the bill is yet to become law. If you come here, the withholding is wrong, grant of assent is wrong, referring is, even reference to the precedent is wrong, reasons are not given, reasons are unnecessary reasons. That's what, my lord, the view has taken. That view, your lordships may have to say correct view or a wrong view. Then constitutional choice in Article 200 is not binary. My lord, I have said, my lord, distinguishing it from Article 356. It's not that whether to appoint president rule or not to. There are several choices and multitude of contingencies to be kept in mind. Lord, one judgment, and I'll read only one part. Lord, somebody came here that criminals should not be inducted into the ministry. My lord, this honorable court, my lord, has said this at page 733. It's a 5-judgment judgment, Manoj Narula. Thus, while interpreting Article 75(1), definitely a disqualification cannot be added. However, it can always be legitimately expected regard being had to the role of minister in Council of Ministers and keeping in view the sanctity of oath he takes, the Prime Minister, while living up to the trust reposed in him, would consider not choosing a person with criminal antecedents against whom charges have been framed for heinous or serious offences, etc. And last, rest has to be left to the wisdom of the Prime Minister. We say nothing more, nothing less. My lord, this applies with equal force to the Honorable President of India and the Governor. Then your lordships may kindly come to, my lord, Khera versus Shergill, page 734. I'll read, my lord, only the highlighted part at 734. My lord, immediately after citing, my lord, New Zealand judgment, the distinctive feature, your lordship gets, highlighted part, my lord. The distinctive feature of all these cases is that once the forbidden area is identified, the court may not adjudicate on the matters within it, even if it is necessary to do so, in order to decide some other issue which itself unquestionably justiciable. Where the non-justiciable issue inhibits the defense of a claim, this may make it necessary to strike out an otherwise justiciable claim on the ground that it cannot fairly be tried. If it is unjusticiable, even connected justiciable issues would also, the court would be refrained from examining. Your lordships, my lord, the chief got that, my lord?
Yes,
Yes. My lord, Article 361, my lord, this is my last point. Please come to, my lord, page 736. Rameshwar Prasad, my lord, my lords, perhaps, my lord, indicated, had in mind para 173. Incidentally, my lord, Justice Narasimha appeared, my lord, in the matter. Para 173, my lord. A plain reading, may I read, my lord, page 737, my lord. A plain reading of the aforesaid articles show that there is a complete bar to the impleading an issue of notice to the President or the Governor, inasmuch as they are not answerable to any court for the exercise of performance of their powers and duties. Most of the actions are taken on the aid and advice of Council of Ministers. The personal immunity from answerability provided in Article 361 does not bar the challenge that may be made to their actions. Under law, such actions, including those actions where the challenge may be based on the allegations of mala fides, are required to be defended by the Union of India or the state as the case may be. By Union of India means President of India and Governor means state. And we are now examining, your lordships are examining a question whether state can file a petition challenging government's action. Then there will be nobody to defend it. even in cases where personal malafidis are alleged and established, it would not be open to the governments to urge that the same cannot be satisfactorily answered because of the immunity granted. In such an eventuality, it is for the respondent defending the action to satisfy the court, either on the basis of the material on record or even filing the affidavit of the person against whom such allegations of personal malafidis are made. Article 361 does not bar filing of an affidavit if one wants to file on his own. I have my reservations, but this is the law declared, my lord, by this court. The bar is only against the power of the court to issue notice or making the president or the governor answerable. In view of the bar, the court cannot issue direction to the president or the governor for even failing to assist, filing affidavit to assist the court. Filing of an affidavit on one's own volition is one thing, then the issue of a direction by the court to file an affidavit. The personal immunity under Article 361(1) is complete, and therefore there is no question of president or the governor being made answerable to the court in respect of even charges of malafidis. I'm citing this as a judgment. As students of law, we may have our views. And, my lord, kindly see in the final conclusion, my lord, at page, my lord, 738, para 179, the position, your lordship gets, my lord. The position in law, therefore, is that the governor enjoys complete immunity. The governor is not answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done or purporting to be done by him in exercise and performance of those powers and duties. The immunity granted by Article 361 does not, however, take away the power of the court to examine the validity of the action, including on the ground of malafidis. But again, this was not in the context of his legislative function under Article 200. In a matter where he cannot be even defended by the state and will not be defended by the state. My lord, in Nabam Rebi, I am not, my lord, reading that judgment, the governor was issued notice. Lord, it was pointed out that 361 is immune. Well, this is a 7-judge bench judgment. The court withdrew the notice issued to the governor. That no, it was a mistake. We should not have issued notice to the governor. Lord, kindly come to my lord.
But he appeared on his own and filed an affidavit.
That's what the judgment also said. On his own volition, he can come.
That is, exactly 2 minutes back, I read that. Exactly 2 minutes back. And both of us appeared, we know that happened. This social media and reels have created a problem. I'll my lord, proceed further, my lord. Please come to, my lord, 741. And this is my last submission, my lord. Para 41. It is submitted that the judicial pronouncement interpreting Article 361 was in the context of an action of the president or governor not relatable to either Article 111 or Article 200 or 201 of the Constitution. The cases decided by this honorable court held that government can answer on behalf of the governor. In practice, the secretary to the governor is joined as a party so as to enable the court to seek the record from the office of the governor to satisfy itself about the existence of material, procedure, etc. But in case of executive functions, here material may be available, but the satisfaction, which can be in the form of grant of assent, which can be in the form of withholding of assent, reference to the assent, or reference to the house. Lord, kindly see the devastating consequence. Suppose the governor refers it back to the house, and if 226 is maintainable, some private citizen will come that why it was referred to the house. Well, would the honorable court, I'm posing a question to myself, start examining pre-enactment actions of the constitutional functionaries? Which is precisely, my lord, the law which is laid down. Lord, therefore, my lord, my submission is neither 32 is maintainable or 226 at the behest of the state. Number 2, even at the behest of private individuals, They are not justiciable questions, and therefore 32 and 226 would not be available. And 311 would also not, no, I'm sorry, 131 would also not be available, my lord, because it is not Union of India and the state or between two states. My lord, I have cited, my lord, BP single judgment, my lord. Because BP single, my lord, 5-judge bench says that, my lord, I'll just note the para, my lord, they are not agents of the Union of India. That's what, my lord, 5-judge bench has said. 7904,
The Union Government of the
Lord, para 40. I'll just read, my lord. Please note the para, page number 7904, BP single, volume 5.20, page 7904, paras 40. He is not an employee of the Union government.
Page number?
7904.
Volume 5 and 14.
Yes, my lord.
20.
5.20, my lord.
What are the parties' name?
My lord, BP single versus Union of India. Lord, para 40. But it says, my lord, he is not an employee of Union of India or agent of the party in power. Lord, para 40, I'll read, my lord, read it fully. It is thus evident, your lordship gets one. I'm sorry, my lord, Justice.
Yes.
It is thus evident that a governor has a dual role. The first is that of a constitutional head of the state, bound by the aid and advice of his council of ministers. The second is a function as a vital link between union government and the state
That's what
government,
I was
which
saying.
my lord the Chief Justice were indicating. He is a link and the state government. In certain special or emergent situations, he may also act as a special representative of the union government. In special my lord, situations, he is required to discharge the functions related to his office, different roles harmoniously, assessing the scope and ambit of each role properly. He is not an employee of the union government, nor the agent of the party in power, nor required to act under the dictates of political parties. There may be occasions when he may have to be impartial or neutral umpire where the views of union government and the state government are in conflict. His peculiar position arises from the fact that the Indian constitution is quasi-federal in character. So, my lord, if governor cannot be joined, governor cannot be made answerable, and it's a issue between union and the state, my lord, I'm putting a question to myself, my lord, who will defend the governor? If the law is right that if he doesn't do it, come to us. If the president doesn't do it, come to us. And they will have to do it in this fashion. My lord, these are my respectful submissions. I'm really grateful for the indulgence. It was an indulgence, my lord, given, my lord, by your lordship so much.
I'll just take a moment, Lord. Our understanding was that this issue was not being addressed, but we have, as state of Andhra Pradesh has filed a 32 Lord. Therefore, I would reserve my right to seek instructions, Lord. If my Lord may permit at the end, I may just respond.
State of Andhra has filed 32.
There are 30, not some other issue, Lord. It's not on the issue. Because in para 13,
Better take instruction.
para 13, the SG's submission is broad-based. 14 qualifies it, 60 qualified, but 13 of the submission.
I'm saying
is broad-based.
202, 201.
I'll have to take instructions. I'll have to take instructions on it. That's all. I'm not saying I want to respond to it, but I'll have to take instructions on it. At the end, I'll just ask your lordship for maybe a few minutes.
It's a proposition of law. I'm not on Telangana, even Madhya Pradesh, Rajasthan, Maharashtra, nobody can file. State of cannot file it. That's all.
You would have to take instructions as to
Certainly.
what is the stand of his case.
Other issues, but we are endorsing and supporting the stand of the AG and the SG. Not this is the opinion.
Yes, certain.
You have seen the timetable, there are, in some states, there are 2 to 3 councils. We have, on this side, we have.
That maybe we have, my lord.
1 minute. Yes. We have, when we are saying something, we don't expect,
My apologies.
when you object to his,
No, I'm sorry.
in In their case, we did not allow more than one counsel per state.
State.
In so far as the other side is concerned, we did not permit more than one counsel to appear for one state. So we will have to make a choice.
Lordship will follow the same.
No, no,
Work it out.
in case of some states, they have given names of 3, 4.
That will have to be adjusted. I'll try and work it out in the lunch first. I'll
Yes,
try and
sir.
work it out in the lunch.
They will have to choose whoever wants,
I understand.
whoever wants to represent.
Work it out in lunch.
This both I will have to sort it out.
Hmm? Wait, please do, my lords. Well, is my submissions, your lordship will find in volume 2.2, starting, I am told, at 470. Open it here. The actual submissions start from 480. The rest is an index.
Volume 2.2.
Volume 2.2,
Volume
Volume
2.2
two-
starts from
Volume Roman 2.2, PDF का page अलग होगा.
PDF, you are telling the PDF page,
No,
running page.
no, running page,
Physical
running
copy.
page.
Volume Roman 2.
Well, this is it, the way it looks like. Running page is given by lordship.
Yeah. हमारा office में
Roman 2.2.
Right, will you be here? I'll be here.
The link is there, though.
It's on the link also, well, it's a hard set also. It actually starts at 480.
Yes.
When your lordship starts using it, your lordships may do me the favor of using the second page on the right side rather than the big page. It'll be easier. When your lordship uses it, lordship will use the smaller page when your lordship uses it, but I'm just for convenience. Let me, well, let's tell lordships in 2 minutes the structure and the sequence. The 3 bigger issues I'll be dealing with. The first, which starts with page 480, that is page 1, is about the whole concept of discretion, the lack of it, the degree of it, etc. in 200, Article 200. So that's the broad discretion point. That is, Balaz, I think up to pages 61 to up to 63, the smaller page 63 of my submissions. It deals with questions 1 and 2. So discretion is a lordship's presidential reference questions 1 and 2. I will then deal, Malus, with questions 3, 4, 6 and 9 collectively, which is broadly judicial review, oblique justiciability, oblique supremacy of judiciary, etc., etc. That will run from 63 to 103. And all are quotations really, because rather than take a lordship to the judgment, the relevant lines are underlined and quoted, as Mr. Mehta has done. The third broad issue, Malus, I'll deal with is the timelines, which will be from page 104 onwards in detail. And then, Malus, I'll deal very briefly with the relatively more subsidiary issues, which is question 8, 10, 11, 13 and 12. That's clubbed together towards the end of the submissions. What I have done, Malus, in structure is that on each head, for example, I'm starting with discretion. I've summarized everything I want to say on that in 2 pages in the beginning to give your lordship the sequiturs and the consequences. And the rest is an elaboration of that broadly in the same sequence. So, if your lordship will turn to 200, which is at page 1, which is page 480, the longer page, lordship will use the smaller page.
Page
480, my first head starts with discretion and Article 200. And in that, in the beginning, I have given in 2 pages all the summary points, 7 points in summary of what I'm saying on discretion, just summarizing the propositions. Willis, the summary is this. First, Willis, I will deal with the fact that the governor and the president, I'm reading para 2, Willis, at page 1, are titular heads functioning within a federal parliamentary form of government, bound by their respective state and central council of ministers, with no discretion as to executive decision making, save and except where so explicitly conferred by the Constitution, that too in a few rare cases.
What about 163?
Fully dealt with once. That's fully dealt with. I'll make good that. And in each system, this is the pattern I'll follow in each, and under each also, CAD first, some case law then, and the first principles. That's directly 163, 162 will be dealt with. Now the para 3 and 4 are interlinked in an interesting way. I am going to say, Willis, that there is strong material as per para 3, give me a minute to oralize, that in each of the three options in Article 200 opening, in each of the three, the governor is bound by the advice of the ministry. In returning back also, and in referring to the president also. And there is material strongly to suggest that. But I immediately after that put para 4, that without prejudice, in the alternative, I have argued fully on the basis that in option 2 and option 3, he is not bound in the first time. But you also will see the material in the para 3 will show that the intention was even for the Council of Ministers to bind him and guide him when he refers his back, how to refer back, when to refer back, if to refer back, and also to the President. But that is not necessary for me to maintain my argument because I put para 4 after that. Let me read 3 and 4 now. There is strong material, especially in Shamsher and Nabam, as also in the last at least 3 speeches in the Constituent Assembly, respectively by Dr. Ambedkar, Mr. Krishnamachari, Mr. Brajeshwar Prasad, to conclude that all the 3 options exercised by the governor under 200, namely, first is assent to a bill, withholding assent or reserving the bill, are intended only to facilitate lawmaking by the Council of Ministers, and therefore each of the 3 options subjects the governor to the binding aid and advice of the Council of Ministers. This is expanded in pages 29 to 44. They are the internal pages, the smaller pages. However, without prejudice to the previous paragraph, and apart from and distinct from it, the governor in any event, has only 3 options, and if he chooses not to assent to the bill, he may, even without being bound by the aid and advice of the Council of Ministers, either return the bill to the State Assembly once or refer it to the President when the governor first receives the bill, assuming he has discretion to do that without being bound in those 2 cases. Fifth is there is no so-called fourth option of making the bill fail or fall through. I'll be showing a phrase, 2 words are plucked completely out of context, completely. And how this one fall through theory, or as he calls it, withholding asset simpliciter, negates the whole of 200 and the first proviso, liquidates it. Then para 6, nor is there any fifth option. So 4th option is not there, nor is there any 5th option of sending the bill for presidential assent after having first exercised the 2nd option of withholding assent, returning it to the State Assembly and receiving it back from the State Assembly under the regime of the first proviso. Actually, and the debates are very interesting on this, whenever they talk of the governor's discretion in other articles, which your Lordship knows well, some articles he's given discretion by the Constitution, they cite 200 only for the 2nd proviso. The governor has a discretion in Article X, in Article Y, which we all agree, there's no dispute. Some judgments, when they cite those articles, club 200, specifically qua the 2nd proviso, which we all agree also, specifically gives the governor discretion. That too subject to the words qua the High Court, not general.
Subject to?
The words given qua the High Court, the 2nd proviso. So that discretion envisaged in the whole of 200 is actually only envisaged limited to 200, second proviso. Only, which has been misread and with great respect is distorted in submitting that he has discretion generally under 200. Now this is the entire summary of my first part. And this runs from up to page 63. All quoted at one place. Let me start with the first part, para 8. The Constitution of India envisages a parliamentary form of government. That I will skip. Para 8.1, while the executive power de facto lies with the Council of Ministers, the executive power is formally expressed to be taken in the name of the governor. Thus, the executive powers are wielded by the Council of Ministers. Then 8.3. The governor does not have any independent discretion in the discharge of their constitutional functions. This is in consonance with both democracy and federalism, and indeed basic structure, which has been held part of basic structure. Whereas the former president called it friend, philosopher and guide, quoting from Pandit Thakurdas Bhargav. He was quoting he was not saying it himself. My submission is that according to me, the governor shall be a guide, philosopher and friend of the ministry, as well as the people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions, and some will be such as will be expressly referred. He will be a man above party, and he will look at the minister and government from a detached standpoint. He will be able to influence the ministers and members of the legislature in such a manner that the administration will run smoothly. In fact, to say that a person like him is merely a dummy, an automaton, or a dignitary without powers is perfectly wrong. Because previous things have said he has a role. He's not a dummy. It is quite right that so far as our conception of a constitutional governor goes, he will have to accept the advice of his ministers in many matters. There are many other matters in which the advice will neither be available nor will be bound to accept that advice. This is Pandit Thakurdas Bhargav. Now let's come, going back from the beginning. Dr. Ambedkar.
He also recognizes that in some matters he will
Which are
bound by the aid and advice of the
expressly conferred. There's a whole list I've given.
And in some matters he may have his discretion.
Some matters he'll be having a
He
discretion.
have to read 200 along with 163.
Therefore, when they say that you have discretion, of course he has discretion. In 5 or 6 listed articles, which I'm going to deal with, one of them is 200, only quay the second proviso. There is no discretion prior to that. If you read it against me, as I've given in the alternative argument, he has one discretion that first time he can refer back or first time he can refer to the president, if you call that discretion. In fact, it's very interesting, but it's not told to your lordships. The 35 Act had a discretion in both the opening words of the counterpart of 200 and in the proviso. Then first round, in the debates of the assembly, they removed the word discretion from the opening part. Then again, there were fights on the word discretion. Then in the second part, they removed the discretion of proviso also. And Dr. Ambedkar comments why. Clear pattern. Idea was to give you discretion only in the second proviso. Therefore, whenever your lordship finds discretion mentioned, 163, 1 and 2 are not blanket provisions. They say they are except in so far as the Constitution says. And the Constitution gives you I've got a list of provisions, take out the list of provisions. One of the list of provisions is 200, but only second proviso. That's the scheme, I want. Now, let us kindly come to Dr. Ambedkar. He calls it purely ornamental. These are not my words, the word ornamental. And the selection of the governor would depend upon the personality, status, character, education, and position. Now, kindly read Dr. Ambedkar. It's been said in the course of the debate, argument against election. Speaking for myself, that was not the argument which influenced me, because I do not accept that even under election, there'd be any kind of rivalry between the Prime Minister and the governor. For the simple reason that the Prime Minister would be elected on the basis of policy, while the governor could not be elected on the basis of policy, because he could have no policy, not having any power. Now, this is when they were debating to elect the governor, not nominate him. So he said, I accept that you elect him, even though there's no rivalry.
Still, he will have no power.
He will have no power. So far as I could visualize, the election of the governor would be on the basis of his personality, even if you're electing him. Look at it, Malas. He has no power even as the elected person. Is he the right sort of person by his status, by his character, by his education, by his position in the public to fill in the post of governor? In the case of the Prime Minister, the position would be, is his program suitable? Is his program right? There could therefore not be any conflict even if we adopt the principle of election. Dr. Ambedkar is very clear, because to say this when you're talking of election is to have a clear clarity about what a governor is in terms of powers. The other argument is, if we are going to have a governor who is purely ornamental, is it necessary to have such a functionary elected at so much cost and trouble? So from being ornamental, he goes to only nomination. Why spend money on elections? Then, Malas, page 5, middle. In my judgment, there is no fundamental distinction between the second alternative and the amendment itself. The second alternative suggested is also a proposal for nomination. It is a variant, Malas, or nomination with some conditions. The only thing is that there are certain qualifications, namely that the president should nominate out of a panel elected by the provincial legislature. But fundamentally, it is a proposal for nomination. In that sense, there is no vital and fundamental difference between the second proposal proposed by the drafting committee and the amendment which has been tabled by Mr. Prasad. Then the boldface lower down. Well, I'm reading the boldface. I'm not trying to avoid anything. I can always read something which missed out by mistake, but it'll save time if I read the boldface subject to some other parts. I want to warn the House that the real issue before the House is really not nomination or election. Because as I said, this functionary is going to be a purely ornamental functionary. How he comes into being, whether by nomination or by some other machinery, is a purely psychological question. What would appeal most to the people? A person nominated or a person in whose nominated the legislature has in some way participated. Beyond that, it seems to me, it has no consequence. Therefore, the thing I want to tell the House is this. The real issue before the House is not nomination or election, but what powers you propose to give to your governor. If the governor is a purely constitutional governor, repeatedly the entire approach is that, fellows. That's why we are called a parliamentary democracy, with no more powers than what we contemplate expressly to give him in the Act. The express power is a proviso of 200, second proviso, and some other provisions. Don't say 28, just keep it open here. If the governor is a purely constitutional governor with no more powers than what we contemplate and has no power to interfere with the internal administration of a provincial ministry, I personally do not see any fundamental objection to the principle of nomination. Then, Malas, I skip the middle para, Mr. Chaudhary, come back to Dr. Ambedkar next para. Well, that power an elected or a nominated governor will have. If he happens to call the wrong person to form a ministry, that's the question Mr. Chaudhary asked. What will happen if he calls the wrong person? He will soon find his cause that he has made a wrong choice. After 3 or 4 lines. That is not the aspect of the question which is material. The aspect of the question which is material is this. Is the governor going to have any power of interference in the working of a ministry which is composed of a majority in the local legislature? If that governor has no power of interference in the internal administration of a ministry which has a majority, then it seems to me that the question whether he is nominated or elected is a wholly immaterial one. Then, Malas, 3 lines later, they should bear in mind this question. What are the powers with which the governor is going to be endowed? Ornamental. Nothing except a constitutional status. That power, I submit, is not before us today. We shall take it up at a later stage when we come to the questions of 200 and 188. Well, as 188 is wrongly, well, what happened was 188 ultimately dropped, never came in any reincarnation. It was found similar to 287, which is 356. But 188 and 287 were overlapping. Ultimately, 287 became 356, 188 went away. 175 is the present 200. The House should be careful and watchful of these new sections that will be placed at a later stage. So 200 is yet to come. He says that and ends that part, Palas. Then next page 8 is Dr. P.K. Sen. Now he confesses that he changed his view. Earlier he had a different view. Now I have a different view is what he says. I must also confess that I am one of those members who have changed their views. What is the change, Palas? Come to the middle of page 8. Since then, on sober and serious reflection, evidently, the members of the House are now persuaded that a general election of that kind, whereby the governor was to be elected by adult suffrage, would impose a tremendous strain upon each province and would hardly subserve the purpose for which it was being held. What is the purpose? The upholding of democratic ideas. The question is whether by interfering, so because democracy itself is the basis when you change him from a non-executive governor to any executive role. Democracy itself is at stake. The question is whether by interfering, the governor would be upholding the democratic idea or subverting it. It would really be a surrender of democracy. We have decided that the governor should be a constitutional head. The premier, well, as the note is that it's the chief,
That is Chief Minister.
chief minister. It used to be called a premier for a long time. With his council of ministers, is really responsible for the good governance of the province. The whole of the executive power is vested in the premier and his council of ministers. That being so, if there is another person who is able to feel that he has got the backing of the whole province behind him, and therefore he can come forward and intervene in the governance of the province, it would really amount to a surrender or subversion of democracy. Well, not in the debate, but somewhere else I read, I'm not able to trace it. The Hindi phrase, ek byan mein do talwar, two swords in one scabbard. That is the antithesis of democratic functioning by an elected chief minister. You should not do anything by implication or interpretation, which will make it two swords in one scabbard. It would make it impossible for the premier or his council of ministers to initiate measures which would be in the best interest of the province. Only in exceptional cases of emergency should he have the power or the function to step in.
If there's a public domain, it is-
It would make it impossible for the premier or his council of ministers to initiate measures which would be in the best interest of the province. Only in exceptional cases of emergency should he have the power or the function to step in and interfere with the actual governance of the province for a short time. 356 came down the line, that time it was 188, became 287, etc., etc. Of course, the condition and circumstances is such. Therefore, in the best interest of democracy, in the best interest of parliamentary form of government, which has been decided upon the basis of the draft constitution, the election of the governor by adult suffrage is uncalled for and inappropriate. The next method of election that is suggested is election by the legislature. There also there is mischief, only in another form. And a conflict would arise between the premier and his council of ministers on the one hand, and the governor and certain other sections of factions which would be in his support. Therefore, I believe that it would, instead of being in the interest of parliamentary government, be a thorn on the side of the premier and the council of ministers, and would prevent them from carrying out any measures which are in the best interests of the province. Then come to the next page, brothers. The function that the governor has to fulfill, as it is now borne in upon the members of the House, is that of a lubricator, if I may use that expression. A facilitator is another word, which he doesn't use. He is not to interfere, but he has to just smooth matters. If there are factions, if the different sections of the community are at loggerheads, it is for him to act more or less as a lubricator, a cementing factor. He is to help the machinery of the government, which is in the hands of the Prime Minister and the Council of Ministers. He is not to come and interfere and cause confusion or chaos. He would be the person really to lubricate the machinery and to see to it that all the wheels are going well by reason not of his interference, but his friendly intervention. And this, I believe, is Mr. Sen, who had a contrary view earlier. He says, I confess I've changed my view. Then, so we've done with the CAD debates. We are only on the general point.
He now supports the view that he should be appointed by the president
Yes.
on the advice of the area and advice of the central government.
Correct. But on the reasoning that any other alternative will give him a role which he should not have. He's formal, he's constitutional, he's titular. It's in his name that you act. The reasoning is what I've quoted, Wallace. Of course, the debate was elect him like this, elect him like that, nominate him like this, nominate him like that.
Elected directly or elected through by the members of the Legislative Assembly or nominated.
That's so this is my first summary still going on, Wallace, on 200, on the first part about the meaning of Wallace, this whole discussion.
Powers of the governor.
Yes, powers of the government. Now, Malas, we've done with the CAD. Now we come to the case law. First, obviously, Shamsher. Shamsher has held the field for decades, Malas. It's 7 judges and it's very comprehensive. I'm only quoting those which are relevant to this on the lines and the thrust of the CAD, of the Constituent Assembly. Under the cabinet system of government, as embodied in our constitution, the governor is the constitutional or formal head of the state. And he exercises all his powers and functions conferred upon him by or under the constitution on the aid and advice of his council of ministers. Now, this is a summary of 163 also, broadly. Save in spheres where the governor is required by or under the constitution to exercise his functions in his discretion. The constitution itself tells you, the text tells you, not some general, omnipresent, omniscient, residual power in the interstices hiding which is inherent in him. No. This court has consistently taken the view that the powers of the president and the powers of the governor are similar to the powers of the crown under the British. It's very interesting, Wallace. They trace it to the crown where it is, I would say, Wallace, it would be horrifying if the Queen ever decided to, Wallace, do any of the things which we are having sometimes now. But just note on the side, it will come later. In my smaller numbered page 28, I have given in para 13.4 a list of those specific powers of the Constitution. Lots of note on the side only, it's coming.
Page?
Well, at page 28, the smaller page, para 13.4, I have listed Article 167, if the governor so requires, 200 proviso second, 356, 371A. There may be more. I've given an illustrative list only. Schedule so and so. Please come back to Malas, para 28. I have my small page 11. Please come back to 11.
Yes.
This court has consistently taken the view that the powers of the president and the powers of the governor are similar to the powers of the crown under the British parliamentary system. And Malas, so many cases are cited. Turn the page. Ram Javai, that famous case, Malas. Then next page. The initiation of legislation, the maintenance of order, the promotion of social and economic welfare, the direction of foreign policy, the carrying on of the general administration of the state are all executive functions. The executive is to act subject to the control of the legislature. The executive power of the union is vested in the president. The president is the formal or constitutional head. The real executive powers are vested in the minister of the cabinet. There is a council of ministers, the prime minister is the head to it. I'm very sorry to say there is a para in Mr. Tushar Mehta's submissions. I'll read that para. Where many of these very things settled by Shamsher years ago, he says the governor may have to hold a bill back because he has to consider these things. And I am assailing that para for another reason. Doomsday scenarios are given. 9 doomsday scenarios which have not happened happily in 75 years of our republic. A state says only Tamilians can enter the state. A state says only local language can be used. Hypothetically, the sky may fall on our heads, bills. My lords have very evocative passages that please don't judge, especially constitutional adjudication, by disaster scenarios. Well, that para has got 9 examples which are unheard of, unthinkable. And happily, with all the distortions of our democracy in 75 years, have not happened in 75 years here. So they are very imaginary, and the imagination is febrile and fertile. Now let us come back to page 12. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate 239, now this is the example Lordship asking where they are given the power. The governor is given power by the Constitution. To illustrate Article 239 states that where a governor is appointed administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. Now, let's just see. This is Shamsher, which is why what is happening is in some paras of other judgments, they quote the same thing as a general 200 without saying second proviso. And then it is used by the government to say that it is general discretion in 200. Shamsher correctly says that they're talking of the second proviso, where of course there is discretion.
When the governor of Punjab
Yes.
is also an administrator for the city of Chandigarh. So for Chandigarh, he would not be bound by the aid and advice practice.
And the
Council of Ministers.
and look at our constitution famous, Malas, they foresaw it, whether then or now in 239. Obviously, it created a ridiculous situation, but my Lord Chief Justice is giving an example. They should not have it, therefore, correctly. So they thought of it, they gave it. Now, the second part is what interests me. Just come to the second part of the same para. My Lord is on page 12. The Honorable Chief Justice mentioned this. Just come to the lower part of page 12. Again, Article 200 requires the governor to reserve for consideration any bill, which in his opinion, if it became law, would so derogate from the powers of the High Court so as to endanger the position which the High Court is designed to fill in the Constitution. This is the second proviso which has discretion. And well, I was just pointing out the error when my Lord the Chief Justice gave that example. In many judgments, 200 is mentioned as an example of discretion, but some judgments, few of them, don't add the subsequent words which Shamsher added. And that is used to say your general discretion. This is the discretion which is in 200. 200 is one of those articles where the governor is given discretion. It is part of my list of 167, 239, etc. But only the second proviso. As the Lordship said of Chandigarh, governor can't allow the High Court to be tinkered with like this. So your Lordship thought of it and put it there. Next paragraph, page 13. In making a report under 356, the governor will be justified in exercising his discretion even against the aided advice. Another example, because 356 says so, there's no question of seeking the aid and advice of the government, of state government, to dismiss the state government. There is no question. Now see the last part of that page 13 minutes. In all other matters where the governor acts in his discretion, he will act in harmony with his council of ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of the council of ministers. And the previous lines I have not underlined to save time are all saying he must act at the aided advice. They say again and again. Now, Mullahs, I had read para 54 above at page 12. My Lord has noted page 12, Mullahs, para 54 I have quoted of Shamsher. Two paras later, they say the same thing in para 56, but they don't use the suffix of the second proviso. So my learned friend says that what is clarified two paras earlier in 56 means you have general discretion in 200. I hope I'm clear with this. Now come to 56 at page 13. Similarly, 200 indicates another instance where the governor may act irrespective of any advice from the council of ministers. In such matters where the governor is to exercise his discretion, he must discharge the duties to the best of his judgment. The governor is required to pursue such courses which are not detrimental to the state. Just a para before that, which is quoted at page 12, they were discussing examples which included the second proviso of 200. This has to be read in that context. It is not an independent source of, otherwise Shamsher for the last 40 years would be read as an independent source of discretion for the governor. Shamsher, your Lordship, cites for every presidential discretion, every governor discretion. If this para is led literally to mean that 56 is not anchored in or relatable to 54, then Malas, he has complete discretion. It can never be. Nobody has read it like this till now. Nobody. Then Malas, page 14. For the foregoing reasons, we hold that the president or the governor acts on the aid and advice of the council of ministers with the prime minister at the head in the case of the union and the chief minister at the head in the case of the states in all matters, which vests in the executive, whether those functions are executive or legislative in character. Neither the president nor the governor is to exercise the executive functions personally. This is Shamsher, 7 judges, 40 years ago. More than 40 years ago. The present appeals concern, ignore that. Now, let's come to Justice Krishna Iyer, not only for the language, but for a very fundamental concept he raised. He said this cuts at the root of our democracy. If you start recognizing the governor as having discretion, he takes it to democracy level, and basic structure. Please see that. Same page 14. thus vindicating our democracy instead of surrendering it to a single summit soul. Single summit soul is a governor, Malas, whose deification is incompatible with the basics of our political architecture, lest national elections become Dead Sea fruits. Legislative organs become labels full of sound and fury signifying nothing. And the Council of Ministers put in a quandary of responsibility to the House of the people and submission to the personal decision of the head of state. This is not fully strong Krishnari language, not difficult to understand, and also is lyrical. Balas. A parliamentary style republic like ours could not have conceptualized its self-liquidation by this process. I think it's a very, very pithy sentence, and very effectively put. Some parts of this Krishna sometimes Balas, make us want to go to the dictionary or to Mr. Shashi Tharoor. But this is not so. This is the truth, Wallace. There are now, I believe, actual classes which my colleague is doing on this. Difficult words thrown to him and he finds a way out.
One of the learned judges in Kerala follows this.
Yes, well, I heard that.
This is Javan Ramjas.
This is simpler Krishna Iyer, J, and very effectively pithy ones. Next para. We declare the law of this branch of our constitution to be that the president and the governor, custodians of all executive and other powers under various articles shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in a few well-known exceptional situations. Without being dogmatic or exhaustive, these situations relate to one, the choice of the Prime Minister. So now your Lordship is spelling out broadly the areas where there has to be discretion. Suppose the House is being dissolved or somewhere the majority is lost, obviously he'll have discretion. You can't be bound, Malas, by those situations. By paramount consideration, you would command a majority. The dismissal of a government which has lost its majority but refuses to quit office. The dissolution of the House where an appeal to the country is necessitous. Although in this area, the head of the state should avoid getting involved in politics and must be advised by his Prime Minister, bracket Chief Minister, who will eventually take the responsibility for the step. We do not examine in detail the constitutional proprieties in these predicaments, except to utter the caution that even here, the action, even here, Malas, even here, where he does have discretion, the action must be compelled by the peril to democracy and the appeal to the House of the country must become blatantly obligatory. Now, Malas, is another interesting example of royal assent, where there is the minimal zero discretion. They give that example. We have no doubt that D. Smith's statement regarding royal assent holds good for the president and the governor in India. Refusal of the royal assent on the ground that the monarch strongly disapproved of a bill or that it was intensely, mark the word, monarch strongly disapproved of a bill. According to Mr. 5 paras of Mr. Mehta's written submissions, he can judge security, friendly relations, need, calm down, cooling period, political considerations, everything he can judge. And 50 years ago, 7 judges said this. 50 years ago. Or that it was intensely controversial, would nevertheless be unconstitutional. Refusal of assent, even though it's intensely controversial,
This is two judges.
and he disapproved.
What you are reading is two judges.
Yeah,
Yes, Krishna.
I stand corrected. This
Yeah.
one is there, this is there. Very well. 2 judges held the field for many decades. Perhaps by laws they want to change it. I don't know. Lordships can. No, just check up. Let me check up. Is it
Is it a minority view?
part of this?
No, it's not.
Concurring. Let me just check up. I want to be sure. What happened was, Balas,
Justice Bhagwati, Justice Ray, Chief Justice Ray was with Justice Bair, Justice Matthew, Justice Chandrachud, Justice Alexis. 5, but both.
so I stand recorrected in my favor. And Mr. Mehta should stand corrected also in his error. Yes, Potomac and Thames is here, isn't that? That the waters of Potomac, not the Potomac, but not the Potomac and the Thames, but the Ganges should fertilize. That part is also in this. But Palas, I was just going to check up. This is all part of the concurring. But I'm sorry, just give me a minute. Just turn to, they are taking it that make it akin to refusal of royal assent. And in royal assent, D. Smith was one book, Wade is the other book. Much before Mullis, in the old days in England, they have said that even if he's intensely controversial and he strongly disapproves, even then, if he withholds assent, it's unconstitutional. I will read the para of Mr. Mehta where he says much more. But he actually in that para makes the governor holding the departments of national security, foreign affairs, and a few other departments. I will read that para. It's not me. Take out that para first. Don't do this. Yes. Your Lordship may well note, because we have done the extracts, please note in volume V 5.7, just for your Lordship, was the correction on the interruption by Mr. Mehta. There should be a correction on that. In V.7, 5.7, page 2912, the actual SCC, Krishna Iyer J. and on behalf of himself and Bhagwati J. concurring. My learned friend Mr. Gopal Subramanian is absolutely right. Then they go on, Malas, the concurrence goes on. The only circumstances in which the withholding of the royal assent might be justifiable would be if the government itself were to advise such a course. If you do not try to distort the constitution, everything falls into place. If you want to achieve a preconceived result, then you'll be distorting. A highly improbable contingency, or possible if it was notorious that a bill had been passed in disregard to mandatory procedural requirements. Since the government, the latter situation with the opinion, etc., that's not relevant for us. So this is, well, some share, 7 judges. Now come to Navam Rebia. My learned friend wants me to read what is not quoted by me. My learned friend just wanted me to read one para which is not quoted by me. The very first para of the judgment of Justice Krishna Iyer, where he starts. Lordship will not pick up, just note the reference, volume V7, page 2912. Just I'm reading it, need not take the V7, 2912. These two appeals by a couple of small judicial officers whose probation has been terminated by orders of concerned ministers in conformity with the recommendation of the High Court have projected constitutional issues whose profound import and broad impact, if accepted,
Which para are you reading?
Opening.
I'm sorry, 2912 or V7, 5.7 or V7. Some of the greatest cases are made from very small litigants with small grievances. This is one such case. But the judges will pick up the larger import, howsoever small the case is. And Justice Krishna Iyer, with his usual felicity, formulated the issue. Have projected constitutional issues whose profound import and broad impact, if accepted, may shake up or reshape the parliamentary cornerstone of our nation. And it did, Shamsher has reshaped because it stood the ground. Great deference and complete concurrence would have otherwise left us merely to say we agree to what has fallen from the learned Chief Justice just now. But when basic principles are assailed with textual support, academic backing, and judicial dicta, speech, not silence, is our option. That's his justification for having a concurrence. Then the later parts I've read. Thank you. Now come to Navam Rebia at my paras, page 16. They said clearly that the apparent executive and legislative powers are in fact not independent powers and are to be carried out strictly on the aid and advice.
You are reading which para?
But I'm now on my page, small page 16. Yes. After now, Shamsher is over, I'm on Navam Rebia. Now, in that page 16 bottom, which is not highlighted perhaps, he explains the above edict is not applicable in situations where the governor is expressly required to exercise his function. The bottom of page 16, Justice Narasimhan.
Yes. After Article 160.
Yes. The question that will need determination at our hands is whether the underlying cardinal principle with reference to the discretionary power of the governor is to be traced from Article 163 or from 161 or from 163(2). Undoubtedly, I'm on the boldface 5 lines later. Undoubtedly, all executive actions of the government of a state are expressed in the name of the governor. He is in that sense, he is the state. Of course, he is the state. His name is there. Even a lordship's ordinary letters come by in the exercise of power done by and under the name of the governor. That, however, does not per se add to the functions and powers of the governor. It is also necessary to appreciate that in the discharge of executive functions, the governor of a state has the power to grant pardons, reprieves, respites or remissions of punishments or to suspend, remit or commute. The governor's power under 161 is undisputedly exercised on the aid and advice of the chief minister. Why, Malus? The governor has full discretion, you will say, because they say the governor may grant pardon. Tomorrow you will argue he has full discretion. The governor's power under 161 is undisputedly, the governor has power to frame rules for the convenient transaction of executive business. This instant responsibility is also discharged on aid and advice. All in all, it is apparent that the governor is not assigned any significant role in the executive functioning of the state. We would also endeavor to examine the duties and responsibilities of the government, the legislative functioning of a state. Well, it's one sentence, I may just digress here. No doubt the governor is part of a legislative process. The word should be process. He is not part of legislation or legislation making. He is part of a process. He is not in any manner a legislature or a legislator. That is clarified by a lordship judgment, which I have quoted here in a minute, in a while. Even though Article 168 postulates that the legislature of a state would comprise of the governor, yet the governor is not assigned any legislative responsibility in any house of the state legislature. This is one part which is clear. And on the next page, the governor shall not be a member of either house. Insofar as the legislative process is concerned, the only function vested with the governor is expressed through 200, which inter alia provides that a bill passed is to be presented to the governor for his assent. And its ancillary provision, 201, wherein a bill passed by the state legislature and presented to the governor may be reserved by the governor for consideration. The only exception to the non-participation of the governor in legislative functions is postulated in 213, where he calls and he, so he only, that means everywhere else he is not part of the legislative function. When he has to do an ordinance, and things like that, because there is nothing there, he is the executive authority in that sense coming out from the, there he plays a role in 213 and 123 in the central case, the central. The only exception to the non-participation of the governor, only one exception, which apparently vests with the governor some legislative power. The governor under 213 can promulgate ordinances during the period not in session. This function also, is exercised undisputedly on the aid and advice of the council with the chief minister as the head. You may have a role, but it is on the aid and advice. Then, next page. The same thing is. Again, they repeat, at page 19. Page 19, they repeat. All in all, it is apparent that the governor is not assigned any significant role, even in the legislative functioning of the state. Now I go to para 148. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions as would assign to him a dominating position, kindly mark those words, over the state executive and the state legislature. The interpretation placed on 163(2), and this is all dealing with both 1:1.
That is what I was asking the learned solicitor from the beginning.
What more domination will you have if you are able to do all the things which the written submissions say you can do? Forget domination, he becomes exclusive authority. Kindly see, your lordship will be distorting the whole scheme for decades. This is only saying a dominating position. That's a very mild word, I would say, compared to what the submission, written submission suggests that you can. I am very sorry to say. It's all right, we are making all that. I, was hearing on VC. The submission is also that a referral back or a refusal can include a money bill. Specific argument was made. I went back to the Constitution, I actually spent 15 minutes, I told my learned friend also. I said, I must have misread something. The answer given to support that argument was that no, It will be so. It was, well, that argument was made and stuck to. But it was supported by reference to 207. I again examined 207. 207 is a very interesting provision, Malas. We have on Fridays in Parliament and in legislature some particular day, to let off steam, we have private member bills, Malas. Friday afternoons are normally kept in most places for private members' bill. They can bring any bill, they let off steam. At the end, Malas, either they withdraw or they get an assurance from the government that we'll look into it. Nothing. There are only about 5 private member bills which have been passed till now, I think, in the entire history. And that too by government adopting it. Now, 207 was enacted that for a financial bill, you cannot have a private member bill. You must do it only with the recommendation of the state. That provision is cited to support that the governor can return a bill which is even a money bill. That's coming later. It's in sync with the submission that the governor is in a he's not a dominating position, he's a super chief minister. Possibly trenching Malas beyond super chief minister also. Now Malas, kindly come back. The above position leaves no room for any doubt that the governor is a dominating position. The interpretation placed on 163(2) on behalf of the respondent is just that effect. Secondly, middle of that paragraph. I'm sorry, my apologies. Because of the following contentions. Firstly, whenever a question arises, whether in discharging a particular function, the governor can or cannot act in his own discretion. According to the respondents, the discretion of the governor on the above position is final, on the above question is final. Secondly, since the provision itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted. According to the respondents, this is exactly the same argument dealt with by Constitutional Bench clearly, makes the governor's orders based on his own discretion immune from judicial review. Now, kindly just give me a minute. I have to go a little slow here. This is where I've stopped now on the full stop, is dealing with those areas where you have given the power to the governor in his discretion. Now the court says that is only those given to you specifically, and even those you are fully subject to judicial review. They are saying 2 points here. Navam Rebia. Kindly read on. Accepting the above position will convert the governor into an all-pervading super constitutional authority. And they've used dominating just 2 paras earlier. This position is not acceptable because an examination of the executive and legislative function of the governor from the surrounding provisions of the Constitution clearly brings out that the governor has not been assigned any significant role, either in the executive or the legislative functioning of the state. The position adopted on behalf of the appellants, on the other hand, augurs well in an overall harmonious construction of the provision of the Constitution. Even on a cursory examination of relevant provisions, we are inclined to accept the submissions advanced on behalf of the appellants. Then, Malas, the next para starts talking of 140. She was asking this question. I'm reading that also, Malas, about 160, what became 163. It was a draft 143, which became 163. Middle of that page 20. The crucial position that is clarified from a perusal of the Constituent Assembly debates, arising from the answer to the query whether the governor should have any discretionary power at all. The debates expound that the retention of discretionary power with the governor was not in any way contrary to the power of responsible government, nor should the same be assumed as a power akin to that vested with the governor under the Government of India 35 Act. And from that emerges the answer that the retention and vesting of discretionary powers with the governor should not be taken in the sense of being contrary to or having the effect of negating the powers of responsible government. Significantly, with reference to the governor's discretionary powers, it was emphasized by Dr. Ambedkar. The clause is a very limited clause. This is 163, 163, 2, everywhere else where is discretion, everything. It says, except insofar as he is by or under this Constitution. Therefore, 163 will have to be read in conjunction with such other articles which specifically reserve the power to the governor. It is not a general clause giving the governor power to disregard the advice of his ministers in any matter in which he finds he ought to disregard it. Therefore, I think the fallacy of the argument of my honorable, therein lies the fallacy. In our considered view, the Constituent Assembly debates leave no room for doubt. But this is Nava Brevia now. They were quoting Dr. Ambedkar. This is the text of the judgment. Have leave no room for any doubt that the framers of the Constitution desired to embody the general and basic principle describing the extent and scope of the discretionary power in 163(1) and not in 2 as suggested. Then, Mullahs, they strongly endorse, and there are very clear passages in Justice Punchi's report. In para so and so, the Justice Punchi Commission, the observations of Dr. Ambedkar have been highlighted. So there's a full connectivity and there is a seamless sync. There is a harmony in what's happening. Dr. Ambedkar says something, 163 says something, your Lordship's case law says something, the Punchi Commission says something, all are in the same direction. All. The governor under the Constitution has no functions which he can discharge by himself, no functions at all. This is Dr. Ambedkar Mullahs. While he has no functions, he has certain duties to perform. And I think the House will do well to bear in mind this distinction. This article nowhere either in A or B or C says that the governor in any particular circumstances may overrule the ministry. Therefore, the criticism that is made somehow enables the governor to interfere or upset with the decision entirely beside the point. Then, Mullahs, they quote, in a very limited field, however, the governor may exercise certain functions in his discretion, as provided in 163(1). The first part of 163(1) requires the governor to act on the aid and advice of his council. There is, however, an exception in the latter part, regard to matters where he is by or under the Constitution required to so function. My Mullahs para, they have given the list of those provisions is page
Page 29.
28, para 13.4.
You have given those 6 instances.
Yes. The expression required signifies that the governor can exercise his discretionary powers only if there is a compelling necessity to do so. It has been held that the expression by or under the Constitution means necessity to exercise such powers may arise from any express provision of the Constitution or by necessary implication. We'd like to add that such necessity may also arise from rules and orders. So you may have such provision. Thus, the scope of discretionary powers as provided in the exceptions has been limited by the clear language of 2 clauses. It is an accepted principle that in a parliamentary democracy with a responsible form of government, the powers of the governor as constitutional or formal head of the state should not be enlarged at the cost of the real executive, council of ministers. The scope of discretionary powers has to be strictly construed, effectively dispelling the apprehension of any that the area for the exercise of discretion covers all or any of the functions to be exercised. This makes the balance perfect. There's no problem with 163 unless you start distorting it. In other words, 163 does not give the governor a general discretionary power to act against or without the advice of his council of ministers. The area for the exercise discretion is limited. Even in this limited area, his choice of action should not be arbitrary or fanciful. It must be a choice dictated by reason, actuated by good faith. We are therefore of the considered view that insofar as the exercise of discretionary powers vested with the governor is concerned, the same is limited to situations wherein a constitutional provision expressly so provides that the governor should act in his own discretion. Additionally, a governor can exercise his functions in his own discretion in situations where an interpretation of the constitutional provision is concerned could not be construed otherwise. So you are compelled to so construe that it must, 356, anybody says you must consult for anything, it will be a ridiculous situation. We therefore hereby reject the contention advanced on behalf that the governor has the freedom to determine when and in which situation he should take a decision in his own discretion without the aid and advice of the chief minister and his council. We accordingly also turn down the contention that whenever the governor in the discharge of his functions takes a decision in his own discretion, the same would be final and binding and beyond the purview of judicial review. We are of the view that finality expressed in 163(2) would apply to functions exercised by the governor in his own discretion, as are permissible within the framework of 163(1), and additionally in situations where the clear intent underlying a constitutional provision so requires, namely where the exercise of such power on the aid and advice would run contrary to the constitutional scheme or would be contradictory in terms. Here, your Lordship is asked to read 200 to nullify 200, the opening and the first proviso. Not to further the constitutional scheme, but to dilute or liquidate it. Now, let's Mr. Kamath in para 13.1 had moved the amendment to remove this except in so far as. That's para 13.1. He didn't like this exception, Malus, in so far as by under the constitution required to access. That's then draft 143, now 163. Mr. Krishnamachari, next para 13.2, opposed it and reassured the assembly that the expression was only a safeguard. And what did he mean? Since independent discretion could be exercised by the governor only under the provisions which specifically require the governor to exercise such discretion, independent of the aid and advice. So Mr. Krishnamachari said that your opposition, Mr. Kamath, may not be justified because this is the object. Next page 25.
Well, I think you won't be finishing it in 5 minutes.
I beg pardon?
Yes, yes.
No, certainly. Well, incidentally, I mentioned Mr. Shashi Tharoor's name in admiration.
Beg your pardon?
Just to clarify the record, I mentioned Mr. Shashi Tharoor's name in admiration. No, just before I mentioned, it's not a defensive comment. I mentioned it in admiration, not in derogation. Willis.
We don't know what is all there on the social media.
This is,
You sorted out with the
yes,
timelines. So we won't permit more than one word.
I'll get the list and just check it out.
3, 3, 4, 4.
No, we are not saying. Don't have.
Yes, Professor.
Well, it's in a lighter vein, this case is about timelines. In a lighter vein, this case is about timelines, about governor and president. Whereas it is easier for Lordship to solve this case on timeline than for me to look at the timelines of that list and solve it. So I leave it to my Lord. I
You
can't
decide
handle
amongst
this.
you. That is what we have followed for the other side. We don't want to deviate from that.
There is some intervening law, but
We can't adjudicate that.
We can't adjudicate.
Jury's
has only three options.
Normally, we don't permit more than one counsel to appear for one side.
So my Lord said 24 minutes
Yes.
of my submissions.
Which Gopal? Two Gopals.
In 24 minutes, that phrase, except in so far as he is by under the, comes up with the CAD. Mr. Kamath was starts and opposes in 13.1 I've read. Yeah, he says this is.
He proposed an amendment to delete that.
That's right. So Mr. Krishnamachari says in text parameters, it is only a safeguard since independent discretion could be exercised by the governor only under the provisions which specifically require the governor to exercise such discretion independent of the aid and advice of the council. Next page 25, middle, boldface. Actually, I think this is more by way of a safeguard because there are specific provisions in this draft constitution which occur subsequently where the governor is empowered to act in his discretion irrespective of the advice tendered by his council of ministers. Then after a few lines, here the general proposition is stated that the governor has normally to act on the advice of his ministers except insofar as the exercise of his discretion is covered by those articles in the constitution in which he is specifically empowered to act in his discretion. So long as there are articles occurring subsequently in the constitution where he is asked to act in his discretion, which completely cover all cases of departure from normal practice, to which I see my honorable friend Mr. Kamath has no objection, I may refer to 188, the overlap of 356. I see no harm in the provision in this article being as it is. If it happens that this House decides that in all the subsequent articles, the discretionary power should not be there as it may conceivably do, this particular provision will be of no use and will fall into disatitude. The point that my honorable friend is trying to make, while he concedes that the discretionary power of the governor can be given under 188, seems to be pointless. If it is given under 188, there is no harm in the mention of it remaining here. No harm can arise by specific mention of this, except of Article 143, that is present 163. 143 is present 163. Therefore, the serious objection Mr. Kamath finds for mention of this exception is pointless. I therefore think the article will be. If it is necessary for the House either to limit the discretionary power of the governor or completely do away with it, it could be done in the articles that occur subsequently, where specific mention is made, without which this power that is mentioned here cannot at all be exercised. Then, Doctor.
Also a discussion that after the subsequent articles are taken into consideration.
Look at it after that.
This could be revisited.
Revisited, exactly. Revisited is the right word. Revisited is the right word. Revisited, and those articles may be having specific provisions saying you have a specific discretion. Then therefore you will fit in then. If you have a specific provision, we have no problem. But this whole argument of general discretion, which your lordship is constantly finding out in case-to-case basis, will create chaos. Then Dr. Ambedkar broadly supports Mr. Krishnamachari and says the same thing, other such articles which specifically reserve. That's what he says. Some of them are coming later, some are there. He says others which reserve. Page 27, next page, after Dr. Ambedkar starts. The clause is a very limited clause, he says, third line 27. It says, except in so far as is by under this clause. Therefore, 143, that is 163, will have to be read in conjunction with such other articles which specifically reserve the power to the governor. It is not a general clause giving the governor power to disregard the advice of his ministers in any matter which he finds he ought to disregard. Therefore, as I have said, having stated there is nothing incompatible with the retention of the discretionary power in the governor in specified cases with the system of responsible government, the only question that arises is how should we provide for the mention of this discretionary power? It seems to me there are three ways by which this could be done. Because he gives those ways, then after some lines. The other way would be to say in 143, except as provided in article so and so, specifically mentioned, or whatever they are. But the point I'm trying to submit is that the House cannot escape from mentioning in some manner that he shall have discretion. Because there are specific articles, so he said we'll say it. Then one is next page, 28. I personally myself would be quite willing to amend the last portion of clause 1 of 143. This is a revisiting point the Honorable Chief Justice made. If I knew at this stage what are the provisions that this Constituent Assembly proposes to make with regard to the vesting of the governor. My difficulty is that we have not as yet come to articles 175 or 188. 175 is present 200. Or no, nor have we exhausted all the possibility of other provisions being made, vesting the governor with discretionary power. If I knew that, I would very readily agree to amend 143 and to mention the specific article. That cannot be done now. Now, as 13.4 is important, though not exhaustive, it is giving your lordship exact provisions which give him that phrase and that discretion. They have exact provision. Empowering, enabling, using diverse words, all are quoted there. They are quoted there. So I have done now, with my proposition, which said that even on a general issue of discretion, no such general discretion was envisaged. This is on the entire concept of discretion of a governor. All the relevant things according to me have been covered. And the thrust, your lordships can have a sentence word here, thrust is clearly that you are not there without specifically conferred discretion. Now I come, to two sets of argument, the first of which is only showing material which I believe has strong resonance to suggest that for each of the three options, first one doesn't matter, but the first one anyway, he gives assent. Second and third option, he still acts on the binding aid and advice, second and third. And immediately after that, I'll come that very well, I don't press the first one. In any case, he at the most will have one referral back and one presidential reference. So I'm dealing with this in separate boxes. Page 29 is my first set of submissions that you'll also see some paras which may throw light on this because you'll also get a complete picture. If I'm partially right or right in this one, then I'm certainly right on the next point. Therefore, just see this passage which suggests that they intended not to have any discretion with the one exception of second proviso. There is page 29. This point runs from 29 to 44. Only on this point that every option has a binding aid and advice of the council. There is strong material, especially in Shamsher and Nabam, as also in at least three speeches in the assembly, that of Dr. Ambedkar, Krishnamachari and British Prasad, to conclude that all the three options exercised by the governor under 200, assent, withholding assent or reserving, are intended only to facilitate lawmaking, this is the rationale, by the Council of Ministers, and therefore each of the three options subjects the governor to the binding aid and advice. Ultimately, the governor is only facilitating. In Article 200, neither the main clause nor the first proviso leave any scope.
Normally, the second option of withhold not arise unless it is a private bill. Because the bill would be presented in the House only on after the cabinet approves it. So there would be no question of withholding it.
No, I've dealt with it. Let me oralize 30 seconds. Now we are considering the argument that all the three options he has to act on the binding aid and advice. My Lord, the Chief rightly asked me, why have a second one of sending back on the binding aid and advice of the council? Right? Well, that's one. The answer is there are many situations where the government wants a rethink, a change of policy. We have noticed some error. We want to make an amendment. We want to make a mid-course correction, or we want to call it back and rethink the whole issue at all. We will not send it back to you. All these are possibilities why you will act even on the second option of sending it back. I'll develop it in a minute.
Okay.
The third option of the presidential arises where the government frequently either knows that this requires presidential assent. There are provisions I am showing where the provision requires presidential assent, the constitutional provision requires presidential, or the government is in doubt that there is some competence issue where it is better that the governor send it to the president.
suppose if the governor himself has doubts,
Therefore,
that-
that is
that-
my next argument.
that.
In this argument, I believe he cannot have a doubt.
No, no,
He's
if-
bound. He's
If,
bound.
if he has a doubt that the statute is repugnant to some central statute,
So, Malas, in my first argument, which is only based,
whether the governor will not have a discretion.
I appreciate, Malas. Therefore, Malas, I've divided it. The next set of arguments is that he has the discretion once to send it back and once to the president. That's the next set of arguments after page 44.
So that is your alternative argument.
Alternative argument.
That he
That's
has a limited discretion.
For me, it makes no difference. Please accept that. But there are 5 pieces of evidence, 2 judgments and 3 speeches, which suggest that my prior argument is not without solid material. That is bound by all 3.
If, for example, something impinges upon 286, 287, then in which case, what would happen?
In which case,
Suppose the bill impinges upon
yes,
issues connected to 286, 287,
yes.
or 288, or certain other, I'm not mentioning all the provisions. And if it comes to him, and definitely the council will not advise it to be referred back, or would always be insisting for an assent,
Yes.
what would he do at that time?
No,
State will anyway not ask for a
yes.
reference to the president.
No, I'm not saying they will ask on this case. I'm saying, Malas, what your lordship is saying,
He has no option according to you. According to you,
He
even
has
if
no
the
option.
bill is apparently
apparently,
impinging upon these
Absolutely.
provisions,
but he is not the judge. I'm agreeing with, my lord is right. The governor is not the judge of illegality.
Take a glaring example. No, we are just asking you, just to test the proposal.
I don't want to take a glaring example of the kind listed there, which I'll be showing in a minute.
No,
those
not
are-
on that basis.
Now,
We are
Malas,
saying if it is apparent
yes.
from the bill that it is impinging upon those specified in the constitution itself, but there is a difference of opinion between the council of ministers and the governor, and governor thinks that it is apparently directly impinges upon,
Yeah.
you are saying that there is no such option for him
So
except to,
what is my answer? The answer in the second set of submission, which I'm now on from page 29 to 44, he has no option.
let's see.
That he has no option. This bill may be illegal. My lord is right. After he appends his signature, it will be challenged in court. Your lordship may or may not strike it
We
down.
wanted to know.
The constitutional scheme will not change about the binding nature of the aided advice. Barring Malas, I don't again repeat want to go to examples that he passes a bill that I take over the Taj Mahal. He passes a bill that the government of India should be
You go
dissolved.
your own way,
So that is not.
but if that approach
Yes.
you take, then the second question becomes even more important.
Yes.
When you say that once it comes back, he has no option. At least at that stage, there is a possibility for him to refer to the president, saying that I've told you that it is impinging. He could have.
That is coming later.
just
I'll
examine
keep in
that.
mind. This,
That is his third argument.
examine that.
that's the argument after that.
If you consider,
That's the argument after that.
The
Because
third option.
I am not
you're
considering
just
it.
flagging it, that's all.
I am glad. I'm very glad.
He said in the beginning itself that there are 3 alternative arguments.
So, Malas, my lord is right, absolutely. That I'm not conceding at all. I'm saying the entire structure I'll read of 200 and the first proviso is the initial stage structure. It's the initial stage structure. In fact, Malas, he then can take chances. The referral back can become a device to refer to the president, which he never thought necessary to refer to the president. Anyway, let me come to that. That will be in its place. Let me first make the first argument only because there are, according to me, some resonance in these 5 pieces, which suggests that in this work, he is bound. His job is not to, in practice, the example my lord Narasimha gave, it is entirely possible in a normal harmonious thing, which we have seen many times. We have known many governors and chief ministers. They'll pick up the phone and say, look, this is not quite right. That is 286. That tradition may be vanishing fast. We don't know. That tradition may be vanishing fast. But, brothers, those are practical solutions to real problems, much lasting nature. But if push comes to shove and your lordship is asking a constitutional question, then this proposition is that he's bound. And it will be set aside by a court of law. So the organ created is your lordships. That's not the organ created. Now, brothers, kindly come to 29. In Article 200, neither the main clause nor the first proviso leaves any scope of discretion with the governor And as a first argument, it is submitted that the provision enables exercise of any and all of the three options under 200 and also of the first proviso only on the binding aid and advice. That's head 2. Before turning to the CAD, it may be stated at the outset on a conceptual basis that the structure of 200 provides firstly for three options read with the first proviso, and the third, as first proviso, also deals with the methodology, mode, manner, and execution of the second of the three options. Well, the point I'm making here is the proviso, first proviso, is basically telling a lordship the mode, methodology, and manner with the second option. It's focusing on the second option.
That is what has been held by the
Lordship, please.
division bench, though we are not in appeal.
No, that's a fact. I must also put at the back of this entire submission the relevant paras on each of these, just for, I know lordship not an appeal, lordship not, but all the relevant paras on each topic of the division bench. Just as an appendix at the end. That's why this is long. It's not that long at all. It's just put there for reference. Now, Willis, para 18. In respect of the second option in Article 200, it is entirely, now this is a conceptual answer to the query Justice Narasimha, Chief Justice also asked, conceptual bills. It is entirely possible that the Assembly or the government, which has sent the bill, wants to reconsider some aspect, alter or amend it, or put it on hold, or permanently stop it, or reflect in it a modified policy perspective. Such situations cannot be exhaustively itemized and can arise in diverse and myriad contexts. In all such cases, the State Assembly could be well within its right to bind the governor by its aid and advice seeking a return of the bill. This is the second option. Then the third option, how does it operate? As far as the third option is concerned, the state government may similarly have decided that certain bills necessarily require presidential assent, without which they may be unconstitutional, entrenching upon contrary central law. This situation again necessitates the binding in and advice of the governor to refer such a bill to the president. Additionally, apart from repugnancy, certain provisions of the constitution themselves require prior presidential assent. This list, fellows, is given here now. These are all, they all say, fellows, unless presidential assent is obtained or provided presidential assent is obtained. Your Lordship may just know an illustrative list. My Lord mentioned 286, 288 is there. 288 is there, 304 is there, 360 is there. Now, I am now trying to give a conceptual reason why they may bind even on the second and third option. Then, fellows, now let us look at the evolution and whether there is a CAD material for this. Turn to the next page, page 31. In under para 20, 20.1, fellows. Section 75. Now, this is interesting. Why I'm arguing that now you have no discretion at all. You have no discretion because discretion was consciously discussed over several sessions and deleted first from the main body and then from the proviso. Let's see that. A bill which has been passed by a provincial legislative assembly, or in the case of a province having a legislative council, has been passed by both chambers of the provincial legislature, shall be presented to the governor, and the governor in his discretion shall declare either that he assents or that he withholds assent therefrom. This is according to me very strong evidence of what Your Lordship now has in contrast and why deleted. Second, provided that the governor may in his discretion return the bill. So two discretions, body and proviso. In the next paragraphs, in the draft constitution prepared by the advisor, draft 147, that is the original, 147 is the original 200, prior to 100. The word discretion was removed from the main clause but retained in the proviso. If my Lord sees I have reproduced 147, my Lord will not find discretion there. It's gone. But in the next line, it remains in the proviso. Provided that where there is only one house of a legislature of a province and the bill has been passed by that house, the governor may in his discretion return the bill together with a message, etc., etc. Now, the governor, just kindly pause here. The governor may in his discretion return. If I delete it, one argument possible is that the possibility of return is also not bound by discretion. It's bound by the aid and advice. This clause said you may return in your discretion. You deleted it. That means for the second option also you are bound by the aid and advice. Let's go further. Subsequently, 175, initially prepared by the drafting committee, discretion was retained in the proviso. Now, well, as it came to the drafting committee, so they retained it in the proviso initially. The first was gone already, they never put it back. Here, Lordship, see that page 33, the proviso retains discretion. This is the next stage in the drafting committee. Now, Malas, Dr. Ambedkar consciously moves an amendment. It's a very, very deliberative, conscious process. Dr. Ambedkar in para 20.4 says, had moved an amendment to remove the word discretion from the proviso also. Come to the next parameters. I beg to move that for the proviso to Article 175, the following proviso be substituted. This proviso, Malas, I can't show negative, does not have discretion. Does not have discretion. Now come to 34. On this also, Malas, the learned SG has a para which has a wrong submission, that they had a parallel main clause. Now just see this. 34. Sir, this is in substitution of the old proviso. This is Dr. Ambedkar speaking. The old proviso contained three important provisions. The first was that it conferred power on the governor to return a bill before assent to the legislature and recommend certain specific points for consideration. The proviso as it stood left the matter of returning the bill to the discretion of himself. So Dr. Ambedkar straight away grapples with the issue directly. Secondly, the right to return the bill with the recommendations applicable to all bills, including money bills. Thirdly, the right was given to the governor to return the bill only in those cases where it was unicameral. It was felt then that in a responsible government, there can be no room for the governor acting on discretion. Therefore, the new proviso deletes. Malas, I have an alternative argument, but I am in no compulsion, I believe, on a weak wicket to press this argument. Malas, just give me a second, Malas. There are three options. The first option is irrelevant because you are assenting to it. There is no issue, Malas. This discussion of discretion arises only in the second and third option. Dr. Ambedkar in the middle of page 34 is giving a direct reason that with responsible governance, there can be no room for the governor acting on discretion in the context of why he deletes the proviso in 200, in present day 200. Then why should your lordship, even for the first time, imagine a discretion to refer back or refer to the president? Your lordship will not be, these examples given, even the milder examples, it will be unconstitutional bill, it will be unconstitutional bill. Of course, governance is premised on the fact that both people collaborate and do the state will not send such a unconstitutional bill, as the milder example my lord gave. And the governor will maybe talk on the telephone and solve it. But if, as I said, at the end, this principle, the intent of the framers is clear. And there can be no better intent of the framer than Dr. Ambedkar himself. He's not even responding. He's moving it, He's moving it. Similarly, it is felt that this right to return the bill should not be extended to a money. Leave the money bill, we'll come to it later. Then, now again, this is very interesting because the dialectic starts, thesis, antithesis, and synthesis. When Dr. Ambedkar speaks, Brajeshwar Prasad raises the antithesis. He complains, why are you deleting discretionary? So we get some more light. He says at page 34 bottom, draft 175, why are you deleting? 35. I am not in favor of this provision. Then he cannot veto a bill that has been twice passed by the assembly. Even that is not acceptable to me. He has not got power in his discretion to veto a bill or to reserve a bill for the consideration of the president. So, second and third option are directly mentioned by Dr. Brajeshwar Prasad, Mr. Brajeshwar Prasad. Well, I hope I'm clear. Mr. Brajeshwar Prasad is touching directly on the second and the third option. And his opposition gives clarity in my respectful, humble submission. Then, after a few lines are not underlined, middle of page 35, Brajeshwar Prasad says, secondly, I am in favor of the president having power to reserve a bill for his consideration on his own initiative and authority. I'm sorry, I have not underlined that.
So it is before that also.
Before.
I want that the governor should have power in his...
I want that the governor should have power and discretion to veto a bill passed, whether passed once or twice by it. I'm grateful. Because that's the governor. Next sentence is president. Secondly, I'm in favor of the president having power to reserve a bill for his own initiative. He should have power to issue an order to the governor directing that a bill passed should be reserved. So president can do that according to Brajeshwar Prasad. I know that this proposition will not be in consonance with what is supposed to be the democratic tendencies people think they are living in a democratic age. There's some typo there, Wallace. But I feel that we are living in a totalitarian age. I want power to be vested in the hands of the governor of vetoing. Now, I want to ask this. Justice, I believe Justice Narasimha's query at least had some element of the last sentence. I may be wrong, but that query is at least some sentiment, not the extreme examples, but some vetoing unjust and unsound legislation. Our framers have thought of it. And one framer objected. And Dr. Ambedkar said no. And Manoj, if this is the basic intent, your lordship is asked to demolish my third lesser argument. Manoj, your lordship is supposed to be saying that even my lesser argument that he has one power of referral back, that is also wrong. I think Manoj, these few underlined lines show clearly that the intent was to give him no discretion, which is why I have given examples why the government may want to bind him for the second option also and the third option also. It is not as the governor will do it. The government may want to do it. That's why the second option was given. That's why the third option was given. Now, Mr. Krishnamachari retorts or responds at page 36. The governor will not be exercising his discretion in the matter of referring a bill back to the House with a message. Directly the language, Balas, if this were the statute or the constitution, it is clear. That provision has gone out of the picture. The governor is no longer vested with any discretion. If it happens that as per Amendment 17, the governor sends a bill back for further consideration, he does so expressly on the advice of his council of ministers. Nobody objects to Krishnamachari, they object to Vijay Prasad. Nobody in the House does. The provision has merely been made to be used if an occasion arises when the formalities envisaged in article, which has already been passed, do not perhaps go through. But there is some point of the bill which has been accepted by the upper house, which the ministry thereafter finds to be modified. Then they will use this procedure. They will use the governor to hold up the further proceedings of the bill and remit it to the lower house with his message. So this is the problem of discretion they are saying. Don't give discretion. There's a flip side to it. One is not so easy. As your lordship is told that even the lesser option is bad. If my honorable friend understands that the governor cannot act on his own, he can only act on the advice of the ministry, then the whole picture will clearly fall in place before him. It may happen that the whole procedure envisaged in 172 also goes through, and then again something might have to be done in the manner laid down by this proviso, but perhaps unlikely. Is what I said. If you want to correct, you may want mid-course correction. It is a saving clause and vests power in the hands of the ministry to remedy a hasty action that they might have undertaken, or enable them to take an action which they feel they ought to do in to meet popular opinion, which is reflected outside the House in some form or another. And for this purpose only the new proviso has been put in. This is a facet which has been ignored. The above shows that Brigeshwar Prasad's understanding was not accepted, and Mr. Krishnamachari's understanding of Dr. Ambedkar's statement was, next page, thus the Union of India's submission in para 82. Now this is the error. I've quoted the word. 182 of the submission is erroneous because it says, I don't know how they say that, brothers. The amendment moved by Dr. Ambedkar to remove discretion from the first proviso was not accompanied by a parallel intention to fetter the main clause powers. Now, this is even factually wrong, leave aside legally wrong. Main clause powers is the previous one they deleted before. Main clause power was deleted much earlier, finished, gone, never brought it back. Subsequently, proviso was also deleted. So, minus 182 saying that the amendment moved by Dr. Ambedkar to remove discretion in the first proviso was not accompanied by, quote, parallel intention to fetter the main clause powers. It's patently wrong, it's factually wrong, legally wrong. Now let us turn to the judgments. So I said, Manoj, there is strongly arguable material, 3 speeches of, most important, I would say not speeches, but Dr. Ambedkar's conception, not challenged by anybody. Now we turn to Shamsher Singh. Shamsher Singh says, in paras 26 at page 37, that there are narrow, rare and exceptional strips of discretion. The word strip is not mine, but the word strip is of Shamsher Singh, which the governor has under the constitution, Justice Iyer, if I remember right. The itemization specifically highlights only the second proviso. Now, this part, my lord, is partly seen. This is the 54, 56. Para 54, which I did in the morning, contrast with 56. Just see the bottom of page 37. Draft Article 175 proviso said that the governor may in his discretion return the bill together with a message requesting the House will reconsider the bill. So Shamsher Singh's 7 judges have accepted this deletion of the discretion. Those words that the governor may in his discretion were omitted when it became 200. The governor under 200 may return the bill with a message requesting that the House will reconsider the bill. Draft 188, which ultimately became a different article as 356, dealt with the provisions in case of grave emergencies. 188 used in his discretion in relation to this is almost 356.
350.
Now come below. Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under to exercise. The provision, now this is, Malas, it's starting with the proviso deletion, then it is coming to 28, then coming to 54. And 54 then stops, says, yes, except where he has directly been given power, and the direct power given to him for discretion is the second proviso. It says so. In 56, 2 paras later, they are summarizing the same thing, but they say 200 alone. They don't say second proviso. That, Malas, can't be the way to interpret this judgment. The provision I'm reading, Malas, bottom of 37. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. Take out this quotation, very important. To illustrate, my lord will just mark para 54 is very important. Article 239 states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise.
Has already been read by.
Done. I'll leave it. 56 also I've done. The next para. Right, Palas?
In fact, I have also read all these in my.
No, Palas, unfortunately not, I think. Unfortunately not. You just trying to check up.
No, I have. You were not here, but.
Where, as far as I can see, my learned friend's assistant has quoted only 56.
No.
Yes, I've got it here. 207. I've got it here. It doesn't matter, Balas, but at least as far as I see, 207 quotes only 56. Does he quote 54 elsewhere? He has quoted 54 elsewhere, but in the quote where he's saying 56, he has quoted only 56. Doesn't matter, Balas. It doesn't matter.
It can be reread.
That's all right. Anyway, let's leave that, Balas. Nobody can change these articles or these provisions or these paras. Now let's go on, Balas. 40.
With respect to who quoted, not quoted, we have to go through.
No, of course.
Draw our own conclusion.
Of course, your Lordship has to. 40. Para 139. Of course, there is some qualitative difference between the position of the president and the governor. The former under 74 has no discretionary powers. The latter too has none. Save in the tiny strips. This is Justice Iyer, Krishna Iyer. In the tiny strips covered, now these are the strips. That's why we say accepted so far the Constitution gives you. 163.2, 371 so-and-so, 371 so-and-so, 6 schedule.
But 163.2 cannot be said to be tiny strip.
No, whatever, I mean, it's a strip which your Lordship knows the scope of it. I mean, we discussed that in the previous section on discretion. It is there. It also is not any wider than what is given to you. It is not an implied discretionary tank of power. Because otherwise 163, all the entire constitutional scheme, 163 can't be, has to be subordinate to the overall scheme of the Constitution. All the other articles. These discretionary powers exist only where expressly spelt out. Now, Justice Iyer, as a concurring judgment, is saying so clearly. And even those are not left to the sweet will of the government, but are remote controlled by the Union Ministry, which is answerable to Parliament for those sections. 5 lines later. For a centrally appointed constitutional functionary to keep a dossier on ministers, this I have read, in the morning. In all its constitutional functions, it is the ministers who act only in the narrow area specifically marked out for discretionary exercise. He is untrammeled by the state ministers' acts and advice. And then, we declare the law without being dogmatic or exhaustive. This part is read, Page 41 was read in the morning. And then at the bottom of 41 is the royal assent point. Nabam has been read also. The same para. Just check it. Nabam also 154, check the morning now, has been read, which follows, Samsher and Nabam go together on this point. Now, Valuri, which is page 43, just before I end this section. To the same effect is Valuri, para 19. The governor is, however, made a component part of the legislature of a state under 168 because every bill passed by the state has to be reserved. Under that article, the governor can adopt one of the three courses. Namely, he may give assent. 2, he may accept in the case of a money bill, withhold his assent, in which case the bill falls through unless the procedure indicated in the first prize is followed. Return the bill to the assembly for reconsideration of the message. He may, bracket. This is why I put Valuri here. I mean, it doesn't matter, I put Samsher and others, but just note this. He may, subject to ministerial advice, reserve the bill for consideration of the president, in which case the president adopt. That's the reason I put it here. This is also constitution bench. So I'm done now, Malas. My second head is over. My third head is, Malas, there are only 3 options. And let us assume that he has discretion in the second and third option to send it once to the state and once to the president. That is, Malas, my third head. It starts from 44. Starts at 44, ends at 54. Malas. This section is page 44 to 54. This third one, which is that textually, contextually, the articles are clear. It is only a 3-option article. And let us accept that for 2 and 3, for option 2 and option 3, he is bound. Sorry, he is not bound by the aid and advice. He is not bound. That's my heading at page 44. Assuming without conceding that the governor is not bound by the aid and advice while exercising the second and third option. In any event, the governor has no 4th option beyond the 3 available to him in the opening words of 200. All the material and above is antithetical to each of the principles advanced by the government on this point of 4th and 5th verse. All the CAD Supreme Court material would be rendered nugatory and is patently antithetical to the concept of the governor in the exercise of the second option. But this is Malas having bizarre results. Just bear with me, I'll paint out some bizarre results. Simply holding back the bill, either indefinitely or neither passing nor returning it, thereby rendering it dead. This would enable the governor to completely negate the will of the assembly and be the last word decider of the fate of legislation proposed by the government. Does your lordship's article suggest that the last word decision on the bill is the governor's? Does any part of the constitution suggest that, Malas? And not of the elected government? Furthermore, now this is very interesting, Malas, this incentivization point. Furthermore, it would incentivize such a governor. That is, Malas, it would incentivize, in case Mr. Mehta is correct, to hold on indefinitely to a bill, because the governor would know that if he sent back the bill, he is subject to a mandatory direction to pass it second time. But he is much better off by not sending it back and immunizing himself from a second reference back. Just hold on, put it in his cupboard and go to sleep. So, why should he send it back at all? Because the lordship is held in a judgment now. That is the contention of the government. Now the contention of the government is lordship should hold by judgment that he can withhold it simpliciter. Then you have actually made the first proviso 0. Because the first proviso, if I send it back and he sends it back to me, I am bound. Why should I send it? It would be a very foolish governor who would want to send it back. And why should he do it at all? This would lead, at the bottom of that page, this would lead to an absurd negation of the entire, well, actually the whole first proviso gets liquidated. I may be exaggerating, but I don't think so. I don't think so. The entire concept of the first proviso is liquidated. Now, a further absurdity on the next page, 45. A further absurdity if you simply withhold. All this is about simply withhold, fall through, withhold, simpliciter. That was the three sub-legs of the argument. The language of Article 200, this, give me this, and the first proviso in particular, give me this page.
You are reading?
Well, it's page 45 now. This is another absurdity of this interpretation.
Okay.
If you so interpret, they are all absurdities if you so interpret it, I'm saying this. A further absurdity would follow if the governor was recognized to have a power to simply withhold assent. The language of 200 and the first proviso in particular is crystal clear that even the limited power of one return is not available to the governor if a money bill is involved. I'll read this in a minute. Moreover, so that is 200 itself says so. Now 199 is one provision before 200. 199(3) says, if any question arises whether a bill introduced in the legislature of a state which has a council is a money bill or not, the decision of the Speaker of the Assembly of such a state thereon shall be final. Now, whereas I am the Speaker, I certify this is a money bill. It goes to the governor. The governor doesn't send it back, doesn't refer it to the president, but under my learned friend Mr. Mehta's theory, he simpliciter withholds assent.
Well, not for money bill. I'm sorry. I never said that.
You did.
Money bill cannot be withheld, but I said that. And I gave the answer also that
allow me to complete. I have thought it out.
No, you have quoted me, therefore. It's not my case that money bill can be withheld.
I apologize. I'm wrong. Actually, your esteemed colleague said so directly. And I hope my memory and my Lord's memory does the same. Mr. Salve argued, and I hope we're going to argue against you on the same side as you, that it will apply to a money bill also. At which point Mr. Mehta intervened to support the argument.
No.
Yes, please.
I said there is
Mr.
no
Mehta needed to
occasion
interrupt
because
me.
money bill is always
Let me be
placed
wrong.
with
I'll tell you how you
Article
supported it.
207 I had
Mr.
shown
Mehta,
that it is
if you don't
placed
mind.
with the concurrence of the governor.
We
So there
heard
is
you-
no question
We
of
heard you
withholding.
with rapt attention. We never interrupted you. Allow me to.
No, I understand. This is the importance of
So,
being
Master-
present when other side is arguing.
Yes. This is, yes. No. This is the importance of also being correct in what the whole world saw, whether you are present or not. You did not raise the point. Mr. Salve raised the point. Question number 1, factually answer yes. Now, question number 2, at which point you invoked 207. Now, this 207 is the next para. Mr. Mehta supported Mr. Salve's argument saying that it is not necessary to have an exemption for a money bill because a money bill will have to come with a governor's recommendation only. Now, therefore, I deal in the next para with 207. Before that, allow me 2 minutes. Let's just turn to the Constitution. Turn to 3 parts of it. First, turn to 199. Then turn to 200. And sometimes they can be more accurate while momentarily not being in court. And sometimes you can be more inaccurate while being sitting in court. That's also possible, Malas. Why is it not possible? 199(3). If any question arises, 199(3). If any question arises, whether a bill introduced in the legislature of a state, which has a legislative council, is a money bill or not, the decision of the Speaker of the Assembly of such state thereon shall be final. Not the Chief Minister, not the Governor, Speaker. Now, Malas 200, the implication of saying that you have a right to simply withhold assent. Simply, that's the argument we are considering. That was the main argument of Mr. Mehta. In that context, see the proviso. Provided that the governor may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill together with a message. So my lords asked the question, this is not Mr. Mehta, this is Mr. Salve, that if you say that you can withhold it simpliciter as Mr. Mehta had argued, then what do you say about a money bill? So my learned friend says it would equally apply to a money bill. That's in the transcripts also. Then, Malas, if that is so, my learned friend says 207, that Mr. Mehta said this time. 207 is the answer to the money bill because the governor and the state would have recommended it and there'd be no need. Now just see that article and just see your lordship interpreted already. 207 has no application at all. Completely wrongly invoked. A bill or amendment making provision for any of the matters specified in A to F shall not be introduced or moved except on the recommendation of the governor is what Mr. Mehta intervened to say. And a bill making such provision shall not be introduced in a legislative council. Now, Malas, this provision facially suggests this. It has been interpreted by the court and otherwise understood to be this is only a provision to bar money bills being moved by private members or financial bills being moved by private members. And secondly, your lordship has held that even here the governor is bound by the recommendation of the state. 207 is bound completely. But the basic purpose of 207 is not that the lordship will hold simplicity of withhold assent even in a money bill because 207 already has a prior consent of the governor. I hope I'm clear. The purpose of 207 is to bar a private member moving anything to do with a financial bill. Second is the case law holds that in 207 also the governor is bound. So just see my para 29.3 now.
Yes.
Kindly come to 29.3 now, on the last part of this argument, of this part. The contention of the learned solicitor that 201 specifically requires
29.3.
29.3 Malas at page 45. So the previous para is the one your lordship has dealt with on money bill. In support of the money bill, 207 is a red herring, Malas. That's not relevant for this reason. The contention of the learned solicitor that 201 specifically requires the recommendation of the governor and consequently even money bill, which the governor in his opinion deems to be unfit or inapposite, can be held back by him, is completely misplaced. 207 is intended for a completely different purpose, wholly inapplicable. The phrase recommendation of the governor, which means the state, governor doesn't mean governor, it means the state, means that no financial bill shall be introduced or moved except by the government and is intended to exclude the moving of any financial bill to private members' bill. The phrase recommendation of the governor, in fact, means the recommendation of the state because 207 does not give any special discretionary powers to the governor. Now, this is held, Malas, in Valuri. This exact same point is held in Valuri. Next page, Malas, 46. And Valuri is talking of 207 itself. Para 18. The governor is a constitutional head of the state executive and therefore has to act on the advice of a council. The governor is, however, made a component part of the legislature. Skip all that, Malas. May I, with your permission, skip it? He also has a similar power of causing to be laid before the state legislature the annual financial statement under 202 and of making demands for grants and recommending money bills under 207. In all these matters, the governor is the constitutional head of the state, is bound by the advice of the Council of Ministers. So this is one part of the answer. This is all part section is on withholding asset simpliciter or the falls through argument, falls through. Now the second part of the same argument, same section, same subject is, Malas, it's a completely artificial, non-existent distinction made between withholding and returning. This argument has been invented to suggest a dichotomy between withholding and returning. Withholding must lead to return. The first leads to the second. There are not two separate options of withholding and returning. For returning, you have to withhold assent, then only you return. It's as simple as that. Kindly come to 29.5 minutes. My learned friend makes an artificial dichotomy saying you have a separate head of withholding simpliciter. Returning is a separate head. So entire first proviso goes. You'll never return. Don't need to return. First proviso is only about return. First proviso is only about return. Whole proviso, 10 lines of the Constitution are irrelevant. The first proviso of 200 is mandatorily linked to and expands upon the second option. Withholding of assent to ensure that the object is not rendered OTOs. Well, just give me 30 seconds on the first proviso. Please see the proviso as drafted. It is directly dealing only with the second option, even as structured. It is crystal clear, Manus. My lord ends the first 5 lines by 3 options. Shall declare either that he assents to the bill, or that he withholds assent, or he reserves. Now the proviso is not a fourth option, it is talking about second option, namely that when the governor may, as soon as possible after presentation, return the bill if it is not a money bill, together with a message requesting. You cannot do it without withholding assent, brothers. Withholding is the first step and returning is the second step. They are composite one. They are one composite integrated steps. That's all. And because thereafter they say, and when a bill is so returned, the House shall reconsider the bill. And if the bill is passed again by the House, with or without amended, and presented, the governor shall not withhold assent. This word withhold assent in the end of, kindly give me a second. The last line of shall not withhold assent in the first proviso is the same as the body of the 200 itself. Same withholding, not some different assent you're withholding. The opening words.
First option is either give assent. First option is to give assent.
That's assent.
Yeah. Third
Second
is
option is withhold assent.
Reserve it for the president.
The middle option in the opening words of 200 and the text itself are withholds assent. And the same words are used in the proviso. The proviso only meant to deal with the second option. And you nullify the second option by saying you may or may not return, but you can withhold permanently. It will make a mockery of the whole proviso.
Yes,
And imagine the harm we are causing to a settled scheme which is delicately balanced. One word here and there. Yes, certainly. The opening words of 200 are short, 5 lines, which in the last 2 lines have 3 options. May I read the last 2 lines? Either that he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill for the consideration. As my Lord the Chief Justice said, the first and the third, leave it aside for a time being. Now the middle word is, or that he withholds assent. The Constitution chooses not to be silent. It addresses in the first proviso the issue. What happens when you withhold assent? Withhold assent is not that you put it in a cupboard and go to sleep over it. The addressing of the Constitution is that when you withhold assent, proviso must follow. And the last 2 lines, last line of the proviso, just see it for a minute, last line of the proviso.
Otherwise, the words as soon as possible.
Well, let's forget as soon as possible. Just give me a minute.
Render OTO.
Very grateful. That's the next one. That's the next submission. It's coming up next. But just for a minute, give me. See the last line of first proviso.
That you can withhold it in eternity.
A that. B, see the last line of the first proviso. Is the same as the second option. Withholding of assent.
Shall not be told.
Shall not withhold. So withholding, Malas, you can't return a bill without withholding. Can you, Malas, return a bill where you are assenting? This is Malas absurd interpretation. Can you return a bill which you are assenting? You must withhold and return. It is part of one intertwined composite process. It's as simple as that. There is no dichotomy unless you want to create a dichotomy. Now, the second argument which is immediately coming, I'll just say it here. As soon as possible also becomes useless. Forget the timeline. There's no question of as soon as possible because there is a fourth option, the covered option, the eternity option. Well, I have a chart coming at the end here. Only of 20 examples. The chart is of 3 states, Telangana, Andhra, and Tamil Nadu. That is of only, well, 20, 30 pages, only for 4 years, 21 to 25.
Telangana, Andhra and. But Andhra is supporting the argument on the other side.
These are not necessarily the same dispensations. 20 to 25 period. Your Lordship knows the changes of dispensation.
We don't know anything.
No, that is, it's a historical fact which the judicial notice can be taken on. Now, forget that. I'm just very interesting. This thing about covered option, pocket veto they call it. There are, nobody has thought of this withholding assent simpliciter. That is an invention in this case only. But indefinite, semi-permanent holding back, that I've selected only 20 egregious cases. 20. I've given a chart of all above 30 days. But 20 out of them have 1468 days.
No, we are not going into facts. I have many bills, my lord, with why we withheld it, etc. We are only on interpretation.
Mr.
Yes.
Mehta, it is not a fact. Because when I come to time...
As my learned brother studied yesterday, the other day, hard facts, bring out good law.
No, hard. It's always hard facts. Makes a bad law. My lord, I have, my lord, the list of
Any
bills
case, we are not going to
which were withheld in past, rightly withheld in past,
My learned friend,
another dispensation, but we cannot decide
We have
interpretation.
to interpret the provision of the
No, yes, I have some list of bills from Andhra
Particular
and
dispensations,
And we
how
are,
to get things.
whatever we will be laying down, we will not be laying down for a particular political party.
but it
It
can
will be
never
about
be
demand.
dependent upon one dispensation, another dispensation. What is
yet
this
again,
argument?
my learned friend,
He may have a list of some 1 or 2 states.
Yet-
I have the national wise details.
yet
I can
again-
show, my lord, right from 1950, what were the bills withheld by the parliament,
Yet
president, etc., etc. But that's not the.
We are not
in which-
going to, we will be interpreting 200.
Exactly, my lord. My learned friend has some list of Andhra, Telangana bills, etc.
Yet
That can't
again,
be, my lord, the way in which
with
you
great
interpret
respect to
constitution.
my esteemed learned friend, is a premature intervention. Hugely premature.
Anyway, you
Nobody is asking a lordship to judge.
forget about the list, you restrict yourself to the
My
interpretation.
learned friend will not decide the way I argue the matter because he doesn't know what I'm talking about. Before I open my mouth,
Dr. Singh invited Mr. Mehta to respond, therefore he took
problem
that.
is, Balas, he is now doing what on a much lesser threshold he accused Mr. Sibal of.
In fact, we are obliged to,
Balas.
we are obliged to both of you. The proceedings will become somewhat boring, so.
No, it can never be boring. It can never be boring. Moment, Balas, we become a little boring, the lordship livens it up also.
Yeah, it brought back life.
Balas, it is not that when I mention a chart, he gets up and interrupts to preclude me by saying question of fact. That is not the issue at all. I'm not arguing any facts.
You said I have a chart of Andhra,
I didn't even
Telangana.
complete my sentence, Mr. Mehta. You interrupted me, just I call it a premature intervention. I was not even. This is not nothing to do with adjudication of facts.
Anyway,
There are-
let us now.
We'll go ahead in the same sequence. Just one sentence. There is a whole section here that felt necessities of the time require an evolutionary, purposive, teleological interpretation of law. That's a legal proposition. Not that your lordship in 1950 did not put a timeline or removed it. The felt necessities of the time require a teleological purposive interpretation is a doctrine of law which I've dealt with. So I am saying not about quashing this act or helping Telangana or going against Tamil Nadu. I am giving a lordship a chart of things which are 3 years old. 2 years president, 1 year governor. 3 years pending today as I speak. Why can't I give that? I'm not asking for any adjudication or any fact. It's just that it's inconvenient for Mr. Mehta to hear it.
No, I have many inconvenient facts for you to show.
Reality.
But are we going on those facts? for
Again-
the purpose
again,
of interpretation.
I am
That's all.
applying the doctrine of felt necessities of the
Right
time.
from
to
1950, I have
interpret-
collected the
no.
facts, but I have not shown it.
My learned, we didn't interrupt at all, Manas. We disagreed with most of what he said. We never interrupted him. Allow me to make my wrong arguments. It's a fundamental right to do some wrong arguments also. Only your lordship has a right to
No,
control us.
he doesn't disagree with me in all arguments. Let him say, my lord, which arguments he agrees, so that
No,
there may be a lesser of the dispute.
Dr. Singhvi argued before us, in quote number 2, that in Kyoto and in the other judgments, court did not frame any timelines insofar as the decision of the speaker is concerned. So the speaker has a right to keep the matters pending unlimited, for unlimited period.
And your lordship knows.
While meeting their argument, we observed that the Constitution bench at that time did not anticipate that the speaker should keep the matters in a cupboard for years together
Yes,
and lead to a situation that patient
operation successful and patient.
patient dead.
I'm
No, I understand. I am
very
saying
happy your lordship
that
is giving
can,
that example.
that can be
30
decided
seconds,
on
Manas.
example.
I'm very happy your lordship gave that example. A, because estoppel applies to your lordship, not to me, Manas. And B,
That's what you said.
more important, your lordship should be consistent and follow that judgment.
We will be consistent, but we are also.
I did bowing down to what Lord.
We also be argued, Mr. Nariman and myself, that this should be struck down as unconstitutional. Don't please put the speaker in that position. 3-2 we.
No, but the reason given was that Mr. A.K. Singh's speech, that our experience with the court and election commission is so bad that the matters are kept pending, and Mr. Sen had given an example about their symbol. That by the time the symbol dispute was decided, they had already won the election on the another symbol. And they thought that the speaker would decide it expeditiously.
Experience was otherwise, and we knew that once a speaker doesn't leave his party when he becomes a speaker, he acts on behalf of the party, and we've seen that happen over years. That's the fact.
Anyway, I am arguing a totally different point, and need not have interrupted me. I am saying that as a doctrine of law, your lordship's purposive interpretation is dynamic and takes into account contemporary realities. Your lordship does not sit in ivory tower. Your lordship sees the felt necessity of the time and interprets the constitution as a living document in the light of that. That's all I was saying. Nothing to do with adjudication on individual state wills. Why can't I say that? Well, infant can't preclude me on that because the facts are very inconvenient. Not that lordship adjudicate that.
Okay, anyway, let's
Right,
go.
right.
We have
Now, it's 46.
enough of
46.
fireworks now.
Page 46.
Now we are fresh. Go for it.
Till Mr. Mehta's next interruption was 29.5.
The Mehta is helping you.
Yes.
So the bench is more receptive in hearing your arguments if the bench is awake.
Yes.
That may well be. No, that but Mr. Mehta's interruptions do help me to also clarify so many things. That I agree with. So I don't
In fact,
grudge
my lord,
it.
it's my mistake, my lord. You should never interrupt a opponent when he's committing a mistake.
Yes.
Please follow that. Please follow that for once.
Interrupted him.
Now, this would be a reel in the evening, my lords.
And also, Malas.
Mr. Sibal demolished the central government.
One more thing, Malas.
Mr. Sibal snubs the SG.
Now, Malas,
There would
no,
be
no, no.
blood as a
Very
real.
important.
There are some pseudo.
Given the frequency of his interruptions, it means I'm right many times, Malas.
Yes.
Given the frequency, that means my rightness is quite a high rate, Malas. Now, Malas, 29.5, page 46. The first proviso of 200 is mandatorily linked. I've read that. Come to the second sentence. The words withhold
Paragraph 29.
29.5. I'm sorry. Your lordship left it Malas, at 200. Just give me 200, 2 minutes first, on 200. My lord were at 200. So 2 points my lord notes at 200. One is that withhold assent is the focus of the proviso. So my lord has noted the same language. Second is as soon as possible. These are meaningless words if the interpretation there is accepted. There is no question that this is absolutely meaningless if your lordship gives this interpretation of withholding assent indefinite. It is completely makes no sense then. In the light of that, the third aspect is the middle of para 29.5 at page 46. Moreover, this is the third aspect. Moreover, the words withholding and returning are not mutually contradictory as interpreted in para 114. They signify two components of the same action. The first leads to the second, or I should say should lead to the second. My learned friend says no. Now, Malus Pillai says this at page 47. Now, this, your lordship may skip, this is on Malus, the proviso's importance. This is not on 200. This is a judgment on the rule of interpretation of a proviso. That Malus provisos have to be read in the connection that they are dealing Malus with in the context. Come to Punjab at 29.7. Punjab, Malus, I had the privilege of assisting the court and was actually very well seriously going into all aspects. Some of the present aspects did not go into, but they saw the whole scheme of 200. 200 was seen in entirety. The present case turns upon how the first proviso is to be construed. It's very important because the first proviso on the withholding asset simpliciter is made as zero, nullity, as per this interpretation. So this para is important. In construing the first proviso, it needs to be noted that the substantive part of 200 provides the governor with three options: an option to assent, an option to withhold, an option to reserve. The first proviso opens with the expression the governor may, in contrast to the second proviso, which begins the expression governor shall not assent. The may in the first proviso is because the first proviso follows the substantive part which contains three options. The first proviso does not qualify the first option, right, police? Nor the third option. That's how my Lord the Chief Justice said first and third are out. The first proviso attaches to the second option, withholding of assent, and hence begins with an enabling expression may. By the mandate of the second proviso, there is an embargo on the High Court issue. Leave that aside, brothers. The governor is by the mandate required to reserve. The second proviso impacts upon the option which is provided for the substantive part of 200 to reserve a bill for the consideration of the President by making it mandatory in the situation envisaged there. The option of reserving a bill for the consideration of President is turned into a mandate where the governor has no option but to reserve it for the consideration. The second proviso is therefore in the nature of an exception to the option which is granted by the substantive part. Right, Wallace? Now I'm asking myself, second proviso is given all the weight. Then why is the first proviso not linked to the second option? This is another aspect. My learned friend is treating the first proviso as unconnected to the second option. Falls through, withholds assent. The interpretation just told to your lordship in these two paras is first proviso linked to second option, second proviso linked to third option in a narrow case of the High Court. On this interpretation, why is the first proviso to be given no connectivity and link with the withholding of assent? Namely, withhold assent and send it back, return it with a message, without a message, money bill, blah, blah, etc. How can you interpret a proviso like this, fellows? You give some weight to the second proviso, you ignore the first proviso. It's unheard of, fellows. Now come to the next paragraph. This is compatible with the fundamental tenet of a parliamentary form of government, where the power to enact legislation is entrusted to the elected reps of the state. The governor, as a guiding statesman, may recommend reconsideration of the entirety of the bill or any part thereof, and even indicate the desirability of introducing amendments. However, the ultimate decision on whether or not to accept the advice of the governor as contained in the message belongs to the legislature alone. That the measure of the governor does not bind the legislature is evident from this expression if the bill is passed, again with or without amendments. Then, Malas, come to the middle of para 24. Middle of para 24. This is the as soon as.
This is by a bench strength of?
Division bench.
Okay.
Three judges. The expression as soon as possible is significant is the middle of page 49. It conveys a constitutional imperative of expedition. Failure to take a call and keeping a bill duly passed for indeterminate periods. My friend says permanently, actually you can just withhold it. Is a course of action inconsistent with that expression. Constitutional language is not surplusage. In state of Telangana, this court observed expression as soon as possible has significant constitutional content and must be borne in mind by constitutional authorities. My lords have used it, my lords have applied it, my lords have given weight to it. The Constitution evidently contains this provision bearing in mind the importance which has been attached to the power of legislation, which squarely lies in the domain of the state legislature. The governor cannot be at liberty to keep the bill pending indefinitely without any action. The governor cannot be at liberty to keep the bill pending. Now, the argument can be, you must please overrule a three-judge bench. This last sentence has to be overruled by a constitution bench for the other side's argument to be correct. There's no other way.
This is contrary to previous constitution benches, is what he said.
And Malas, it is contrary to previous constitution benches that for the two words falling through. If you don't hold it contrary, there is no falling through. Malas, falling through is coming.
Key consideration, unless, they use the word unless.
Unless the first proviso, that is next para of mine says that.
The argument is that
If you don't use the first
if
proviso.
you don't use the first proviso, the bill falls.
Now, Malas, the first proviso is interlinked. You have to use it.
First proviso has a may.
Three judges. Different bench of me. It's
Ah,
contrary to-
Kameshwar and all that. Kameshwar.
That's what it says. Which is really that is really that.
To 60 is a section on falling through.
How do you beat those two constitution judgments,
Kameshwar and that's exactly
which say that the,
Kameshwar and the other one.
if he withholds it, the bill will fall through unless it is.
Page 55 to 60.
So that is their argument.
Exactly.
Their argument is that if the governor doesn't decide to take an option of the proviso, the bill will fail.
So my lord is on page 50. Page 55 to 60 is that argument. I'm coming to it.
You are coming to that, yes.
Yeah. And since you should ask the question, give me 30 seconds. A, Kameshwar and that Valuri have nothing to do with this subject which we're discussing here. I've dealt with it. But more important, they have nothing to do with it at all. More important, what they are saying is, if the procedure of the first proviso is not followed, which means that the state doesn't send it back, it will fall through. That one word falls through, plucked out, is completely wrongly put. If I withhold and they send it back to the state and the state never sends it back, it will fall through. That's all there is to it. But let me come in 5 minutes there. Let me finish this at page 50 now. Or should be at 50.
So your submission is that once the governor withholds the assent, he
has
makes
to
a
send it
declaration
back
to that effect.
Because the first proviso has to send it back.
Yes, to send it,
He
yes.
has to mandatorily send it back.
Mandatory.
Then why the word may has been used there,
May-
not shall?
No, Malas, means that Malas, may is a form of
Everywhere else it is
option.
shall,
It's an
shall,
enabling
shall.
option. No.
Second proviso also it is shall. Why may here?
Whereas may is not meant for this option. May is meant that he, in a particular circumstance, may want to withhold assent, then he must send back. May withhold. He doesn't withhold assent every time. He can give assent. He may not withhold assent. He may withhold assent. He may refer. This thing happens after you withhold assent. The moment I may exercise one option of withholding assent, I must send it back. But whether I exercise the option of holding it back or not is one of the three options.
Correct?
So that's the may. The may is not that after withholding, I have an option not to send it back. There is no may like for that. Well, otherwise, the whole kindly see if your lordship applies the proviso. If the proviso is read to mean
Have been like, provided that the governor where he withholds the assent, shall send it back. Simple as that. Why complicate it with may and shall and all different terminology? Where the governor withholds the assent, declares, makes a declaration, he shall send it back to the house with or without a message for consideration.
no, but it makes sense. I'll tell you why. May in the proviso links to the previous line. There are three options the governor has. Then this may not arise in the first and third option at all. Now, this proviso is put to consider solo a second option only. In the second option, you have to reach that option. But once you reach the option which is withholding assent, second option, there is no further option may not send. That will otherwise, suppose, let me look at it common sensically. Suppose your lordship reads the first proviso to mean that he may not send back.
With the common sense, we are dealing with the provision here, we are interpreting it.
No.
Common sense may be lacking, is that something different? Huh?
No. Whereas somebody said that law is supposed to be common sense, but frequently it is uncommon nonsense. That's a different matter. But when we can't, this is not, there's no problem with the constitution on this. I'll show you in a minute. My lords are conferring. Now, listen. The falls through happens when on first withholding assent, you have to send it back. That is mandatory. The state may not send it back to you after reconsideration for repassing. That is the falling through. It makes perfect sense. The reason why he may send it back is because he may assent. The reason he may send it back is he may give to the president. The may does not give him an option that withholding assent means covering in his cupboard and never sending it back to the state.
Your side argued that
The
may
other
should be read as shall. Before the two judgments.
No, that is because in the contextually it will be shall. The whole proviso is a shall.
So that's your argument. that
Yes,
is
sir.
shall.
Contextually, the proviso has to mean shall the moment he withholds assent. The moment he withholds assent, it has to be shall. In the
What's your argument before the two judge bench?
yes, sir. Absolutely. Now, your lordship also looks at the various facets of interpretation. Take a case, just forget the word common sense. Take purely constitutional law, and we can't ascribe lack of common sense to one of our founding fathers. But if your lordships were to have the option of indefinitely holding the bill in your cupboard, because there is no declaration by him, he just does nothing, he just keeps it back. Withholding assent is no message, nothing, keep it
That
back.
is the situation where he has not exercised any of the three options.
Any other three options.
Correct.
Then, Malas, why will a situation ever arise unless he wants of returning the bill? I am the state. I have sent the bill to him. My intention is to pass it. All this discretion, titular head. That means, Malas, out of 100 bills, some governor will send back 99. Some will send back 1. And by keeping it back, he achieves a far larger power than lordship has anywhere in 200. Power, he can nullify all the options, brothers. His power becomes larger than the president because he refers president may do it. His power to assent not necessary. Then he becomes the controlling authority, not the passer of the bill, me, but he becomes the boss. Dominating will, dominating all this. It will run a coach and four through the entire structure.
All
And my lords, brothers, have read may as shall in the context hundreds of times.
right. Yes.
But that falls through. I must have come back in 3 minutes. Just let me finish 3 pages more. It's coming in 3 minutes. Kameshwar, and that's completely mistakenly applied. Come to 25. Page 49, para 25. The governor, as an unelected head of state, is entrusted with certain constitutional powers. This power cannot be used to thwart the normal course of lawmaking by the state legislatures. Consequently, if the governor decides to withhold assent under the substantive part of 200, the logical course of action is to pursue the course indicated in the first proviso of the bill to remit it back to the state for reconsideration. Well, this your lordship is reading from Malaz, Punjab judgment at 29.7. It starts at page 47. Since your lordship has got a long para here. This is very important. They've dealt with this exact case. Of course, it is open to constitutional to disagree. Is it such a wrong reasoning here which your lordship disagree with? That is a different issue. If the first proviso, page 50, is not read in juxtaposition to the power to withhold assent conferred by the substantive part of 200, the governor, as the unelected head of state, would be in a position to virtually veto the function of the legislative domain by a duly elected legislature by simply declaring that assent is withheld without any further recourse. In fact, one is theoretically any bill and any time. And you may suddenly wake up after 5 years and say, no, I'm passing the bill now. Such a course of action would be contrary to fundamental principles of a constitutional democracy based on a parliamentary pattern of governance. Therefore, when the governor decides to withhold assent under the substantive part of 200, the course of action which is to be followed is that which is indicated in the first proviso. Apart from the fact that your lordship doesn't adopt an interpretation which makes that proviso nugatory. That also is another aid of interpretation your lordship follows. Then come Malaz to 29.8, which is at page 50 bottom. Turning now to the third option, the structure of the opening words make it clear that all the 3 options are contemplated in the initial stage of the bill being received by the governor, not later. It is also clear that each of the 3 are mutually exclusive and non-overlapping. Since or is used, disjunctive is or, Malaz. In para 19, I've already done it above, Malaz, which is at page 43 of my earlier page of my written submissions. Also finds 3 this is Valuri saying so, Malaz. It says so. 3 alternative, mutually exclusive and non-overlapping options. It is further submitted that once the governor has used one option, namely the option of returning the bill back, he has chosen one of the finite 3 alternative options. It is contrary to all constitutional text, CAD and Supreme Court jurisprudence to allow the governor to use a reference back from the assembly as a device to exercise the original third alternative. It becomes a device. And see one more very great anomaly. You think that this should be returned. This is my second argument on my second basis that you are not bound by the aided advice and you can return it on your own.
No, but suppose if the governor finds that some of the provisions in the statute are repugnant to a central statute, and he advised that please look into this and reconsider whether this provision should be there or not. And if it is returned,
2 answers.
the legislature passes the bill as it is without any modification.
Lordship.
Then can't he send it to the president? Can't he reserve it for the president to consider whether?
The answer is no for the following reason. In the first instance, on my first model, his reference on all 3 options is bound by the aided advice. I finished that argument. That my lord is noted. So on that, he has no discretion. 0. On my second basis, I send him a bill. He finds an error, which he believes should be sent back. The act of sending back is an exclusion of the third alternative. At that stage itself.
How?
Because he has 3 options when he receives.
Then if in his wisdom, he finds that I should give one opportunity to the legislature to correct the error committed, and quite possible the better wisdom may prevail upon the legislature and find that particular provisions are repugnant to the central
Right.
statute, and they may delete that
I'm answering.
and pass a bill, and thereafter he may give assent. But suppose even if with that message,
So may I say?
so the bill is passed as it is, then can't he send it to the president
Why?
to find
Two
find out
reasons.
whether these provisions are repugnant to the central statute or not?
Two reasons. One, on my alternative argument, obviously, not my main argument. We are only seeing that. He gets the three options first.
But
Applies.
we are aware, he gets the three options there. We are not.
No,
We
I'm
are not
answering.
quarrel on that. He gets the third option.
When it comes back.
And the first option itself, he has an option
Yes,
to send it, to reserve it for the president,
right.
being certain provisions repugnant. But rather than doing so, if you find that, I will give an opportunity to the state legislature to correct itself, and
No, so therefore, that he can do A by referring it first and B answer to my Lord's query. He cannot do it second because it violates the first proviso which mandates him to pass it. Because you have now exercised the will of the legislature, which says you shall pass on a second.
then only option would be for the court to examine whether it is.
Yes, that's the third answer. If there is this question my Lord is asking about repugnancy, error, legality, is available only to the courts. He is not a judicial reviewer. Absolutely right, Mulu, with great respect, with great humility. This is a balance between the elected legislature. Somebody said the elected government has the duty to do right, but it also has the power to do wrong. And the power to do wrong of an elected legislature is a great power which is only in many cases settlable either in the courts or in the next hustings. That's why Your Lordship cautious every day, Manas. Your Lordship stays every day. If the governor starts saying, I believe it is repugnant, now twice the state has said, no, it's not. First it sent you, the state did not think so. Second time the state sent you back, the state doesn't think so. Who are you to think so? You can't. If it is that,
And your argument would be that the second proviso,
will be,
no,
not second,
is
first.
only for a limited area.
No, second proviso doesn't come into it. Second proviso doesn't come into it at all. Second proviso is the only one which gives him discretion completely. Second proviso will not come into this example at all, because that is the one proviso which gives him complete discretion. Where, of course, he has to satisfy the language.
That in his opinion.
I don't know. Opinion, etc.
Chief Justice's question to you was on the second issue that you have raised.
Yes,
That is on the textual interpretation of the proviso.
yes.
You have gone past the first stage of aid and advice, but you must answer the textual
And-
interpretation of the
Yes.
proviso.
And
Why
when a
can't
bill,
it be linked to, why should it be?
yes,
Agree.
and when a bill is so returned, the house or houses shall reconsider the bill. Now, the consideration that is repugnant, it's bad, is unconstitutional, all that has gone into the state a second time and the houses. And if the bill is passed again by the house or houses, with or without amendment,
It shall be
and
assented.
presented, the governor shall not
Assent.
withhold. Now he says,
Governor
refer
shall
it.
assent.
Shall assent.
Not-
Now,
Does it say that?
So in other words, the governor shall grant assent.
yeah, shall. Obviously, absolutely. Shall not withhold, is of course shall assent. Nobody argued such, happily till now that will also not be 100% yes. Now, Malaj, you may have had a provision for a second reference. You may find a legitimate ground of repugnancy. You have to leave it to the wisdom of the courts. The courts are the only recourse. Malaj, once your lordship has a order, a judicial order, giving your lordship
No,
a thought.
entertainment of this.
Somebody is responding to my arguments.
Not from this side.
Now, when you have had first one chance, then the legislature has had two chances, you applied your mind, nothing is, somebody said, your lordships is right because you are final. Somebody said, your lordships are right because you are final. You are not
We are not final
you are
because
right.
we are right.
Therefore, Malas, if I keep on checking with your lordships, rightness is not something which, this rightness can only come to your lordship. Lordship can't go to the governor. Otherwise, why do you have a legislature? Why do you have a second reference? And well, how does your lordship then reconcile the last 4 lines of the first proviso? And the contrast, that's another point, Willis. The contrast of the last 3 lines of the proviso with the second proviso, which says, yes, you may have a discretion. For high court matters, it gives you a discretion. Well, that would be making it, and Willis, if it is so repugnant as the lordship puts it, I am saying clearly he has no business to go into repugnancy. He is not the judge of that. But if he has so much, the first reference where he could refer to the President of India. Yes. Whether it is a review or a curative, I don't know. It's a review or a curative.
It happens in chambers.
According to me, Malad, this would be beyond a curative. As far as the constitution is concerned, it gives you no right. There is no hurrah here, which gives you a second bite. There is no hurrah here, giving you a second bite. Now just see here also, Malad. 29.9, page 51. This is Valuri again, another paragraph, with the same 19 paragraph. Under that article, the governor can adopt one of the 3 courses. Can adopt one of the 3. This is alternative, 3 alternatives, not overlapping, not conjunctive. He may give his assent. He may accept in the case of money bill, withhold his assent, in which case it falls through unless the procedure indicated in the first proviso is followed. That is, return the bill to the assembly for reconsideration. It falls through only when the return, the assembly doesn't pass it. That's the meaning of fall through. The governor can't make it fall through. It all harmonizes. He may, subject to ministerial advice, reserve the bill for the consideration, in which case the president adopt the procedure. The first proviso to 200 deals with the situation where a governor is bound to give his assent when the bill is reconsidered and passed by the assembly. Then, Malas, forget Lakshmi Narayana, this general interpretation.
But then how do you withhold his assent therefrom, in which case the bill falls through? Unless the procedure
Unless the bills falls through, if when the procedure of the proviso is followed, the state does not repass it or resend it. That's how it falls through. If the procedure is not followed, the state does not repass it. Well, the state can have 5 reasons. It amends it, it keeps it in limbo, it rethinks it, doesn't send it back. That's the only reasonable way of interpreting it. Loses interest in the bill, whatever. Malats, the proviso and the second option.
It doesn't say that the governor has to mandatorily return it. On the contrary, the wordings are unless the procedure indicated.
Malats, falling through. Falls through now, my lord has asked me more than once. It's coming next. One digression before that. Please turn to my learned friend, Mr. Tushar Mehta's para 100 for 30 seconds. Para 100 is at volume 1.1, page 155. This is the last point before I come to falls through again.
Yes. Page 1.
Which is at page 155 of Mr. Mehta's volume 1.1, which my lord was using earlier. The main submissions of Mr. Mehta.
Page 156.
55 and 56. So they are the main submissions my lord was using.
Paragraph 101,
100.
100. Where he has given so many examples.
I'm not even going to read them. Your lordship may see it, Wallace. This is the basis for arguing that the governor must be given a judicial review or a gubernatorial review power. Because disasters will happen and the sky will fall on our heads. See any example. State legislature will pass an amendment to the constitution. Your lordship may be well as having the reverse situation, or not this one. They remove the concept of reservation altogether, based only on religion. Well, take any of them. I mean, I'm not going to details. Therefore, Malas, my lord has said in the last part of this section, page 54 of my note, this is not the way to do constitutional adjudication. On that basis, my lord will never do any constitutional adjudication because your lordship will be looking at extreme scenarios. Your lordship has said so at page 54 of my note, my submissions, page 54. I've quoted one out of many. We are clearly of the opinion that the argument about the relevance of this matter is incorrect. This court has in numerous rulings to which it is unnecessary to refer that the possibility of abuse of the powers and the provisions contained in any statute is no ground for declaring. But this is much more. This is disaster scenarios. This is one of absolute extreme things. Now, Malas, on falls through, this I already told Malas, falls through means it has to go back and not come back. I will now let me analyze Kameshwar and this other one, Malas. Valuri. Actually, Kameshwar is the only one because Valuri and Hecht follow completely as it is. So we'll just come to Kameshwar in page 55, para 33. While considering a different question, now as Kameshwar at page 55 is dealing with a totally different question. So keep that in mind. So different that that one phrase is completely out of context. A different question, whether a bill has to be granted assent by the governor to become a law for it to be referred to the consideration of the president. Now, this is a little extreme argument that you must first grant assent and then refer it. I hope I'm clear. That is the question. In that context, Wallace, in the middle of page 55, lower part, not middle, it is therefore it is urged that after a bill is passed by the state assembly, the governor must assent to it so that the bill becomes a law, and then that law to have effect must be reserved for the consideration. This is a far-fetched argument, and there is no connection with our case. 2 lines later, I am unable to accept this line of reasoning. I don't understand how any court could accept this. That you must first pass the bill, then refer it to the president. That means it become law, allow it to become illegal law, and then refer it to the president. The procedure to be followed after a bill is passed is laid down in 200. So they discuss periphery in that context. Under that article, the governor can do one of 3 things, namely, he may declare that he assents to it, in which case the bill becomes a law, or he may declare that he withholds assent, in which case the bill falls through, unless the procedure indicated in the proviso is followed. The procedure in the proviso is they must return it back.
Why does it say unless?
Unless, because it falls through if the procedure in the proviso which is returning back of the bill doesn't happen. It will fall through. If the state doesn't return it back, the bill will fall through. The proviso says the procedure is to send it back. The proviso was created for the state to send it back, after which you have to pass it. The state may for 100 reasons choose not to send it back. The state may for 100 reasons amend it out of recognition. The state may put it in cold storage.
If it goes back, it never comes back, then there is no question of the governor granting any assent or sending it to the president or for whatever.
Exactly.
That is their argument, that the governor is bound to return it to the legislature. And if the legislature doesn't follow the procedure, it doesn't pass the bill, then it falls. Am I correctly understanding your argument?
With great respect, yes. And one more thing. This is one answer, clear.
If the legislature decides not to proceed further,
That's right, it falls through.
then the bill will fall.
Because the procedure in,
So far as the governor is concerned,
he has no power.
according to you, he is mandated to return it to the.
Connected with the basic concept that the consequences will render the whole of the first proviso nugatory, because if the governor has an independent power of locking it in his cupboard, then your lordship is giving a go by actually to all the 3 options and making this the most dominant super option.
Are there any discussions in these judgments on falls through?
This is all. My learned, nobody has till now plucked out these 2 words. These 2 words have been plucked out only by the ingenuity in this case.
When
There is
the
no
bill-
judgment.
Mr.
So I am putting in,
When the bill is with the legislature or the parliament, only thing that will happen if it doesn't go further, it will lapse.
Lapse, doesn't it?
What is the concept of a falling through when the
this is
bill
not a
is
statutory
actually
language. This is,
within the hold of a
no, Bharat, this
legislature?
is not a statutory language. Falls through is a colloquial language. Correct. The fall through is a colloquial language.
Either way, you are right, you
Yes.
are right. The judgment is not to be read as a statute.
Yes, yes.
Either way, it has created much of a problem in its interpretation. But then, when it goes back, it will fall through is not a correct expression to
Whereas
use.
we are using, you are
It
right.
is in the domain
My
of
lord
the
is right.
legislature or the parliament.
My-
If nothing happens, the bill lapses.
No, not, my
If
lord.
it is in the governor, it doesn't lapse.
My lord is right, Willis. These are not words, terms used in this para as terms of art.
Correct? Absolutely.
Now, fortunately for me, they have added unless the procedure indicating the first prize is followed. Now, clearly that procedure, suppose, well, there are only two options. Suppose that procedure is that the bill is sent back to the governor. Then can it fall through, Malus? Suppose the state sends it back to the governor. Can it fall through? It can't.
Then he is bound to give assent to it.
It can only fall through.
Even if the assembly
for a
is
variety-
dissolved also, it doesn't.
I beg your-
Even after dissolution, if it is in the governor, it doesn't. It continues to be.
That's the very it says that it doesn't,
Doesn't.
even if after dissolution,
Back to the assembly, that is what.
No, Manas, we are allow me. We are considering only one argument. Withholding assent simpliciter is a head by itself. That's all. All these are sub arguments under that. You can withhold simpliciter, which is neither assenting nor sending back nor precedential reference, nothing. Now, one of the sub arguments of that is that I hold it back and it falls through. Namely, I, the governor, decide the fate of any bill at my subjective absolute discretion. Well, all the things I've read about discretion will be nullified then. I, the governor, decide, first forget the word fall through. There's no fall through separate argument, although we're reading it separately. The argument is that the withhold assent simpliciter is not an assent, not a presidential reference, not a return back. It's a fourth grand option. This fourth option swallows the entire article. And look at the consequences, how unmanageable your lordships any such sentence would be. And Malas, how do you control and guide and Malas, curb and crib and confine the discretion of withholding simpliciter? That's a huge discretion, Malas, beyond anything which Dr. Ambedkar dreamt of. All this will have to be seen, Malas. I'll continue.
so you sort of, time allow this.
I'll work it out.
No, only one council per state.
The principle we follow, no issue.
Very deeply obliged. Very deeply.
Next week would be, I think, second, only 2 days. The 2 days. Second and third.
I beg your pardon?
Next week,
Days of hearing in the next week,
Tuesday.
second and third.
second and third, because fourth would be again,
Tuesday.
Well, one intervening application alone, my lord, has to be allowed. Others, my lord, has been,
no intervention.
No,
already your lordship has allowed it.
This Gopal Shankaran is going
Already
to give us a middle path, so you can follow him.
Deeply obliged.
he is also intervener. Gopal is also intervener.
It is.
You are intervener general of India.